with us. Is that correct,
Yes, sir.
Larry?
Yes, sir.
So if Senator Lapid is online, so the chair thanks him for his presence. Yes, okay, Jen. Although, for the record, Committee Secretary, this is a continuation of our hearing from what date yon, please?
February 16.
February ano?
16, sir.
16. Okay, so ladies and gentlemen, this is a continuation of the last hearing of the Committee on Trade last February 16, 2021. And I thank Senator Lapid for also being present today. Okay, so may I ask our Committee Secretary, Ms. Jingle Concon Alam, to acknowledge the resource persons present for today's hearing. Go ahead, ma'am. Go ahead, ma'am.
Sir, thank you, sir. Sir, if I may, sir, may iba pa rin pong senators on board like Senator Marcos and Cayetano.
The chair acknowledges the presence of Senators Marcos and Cayetano and thanks them for attending this hearing. So continue, ma'am, Comsec.
Yes, sir. Thank you, sir. Good morning, everyone. Thank you for coming to our public hearing. Our resource persons for today, from the government side, we have the Department of Trade and Industry, Assistant Secretary Ann Claire Cabot-Chan.
Good morning, Mr. Chair. Good morning, everyone.
From the Department of Agriculture, we have Attorney Tess Villaverde, Mr. Kennedy Garabiag, and Mr. Ezrael Manzano, Attorney Tejida, and Director Honorio Flamenio. From the Department of Budget and Management, we have Mr. Mark James Evangelista. From the Department of Finance, we have Ms. Annabel Magno. From the Securities and Exchange Commission, we have Commissioner J.B. Paul Francisco, Mr. Romualdo Padilla, together with Attorney Algin Lacanaria and Attorney Darwin Soto. Also from the Philippine Guarantee Corporation, we have Attorney Isabelo Gumaro. From the Department of Transportation, Land Transportation Office, we have Assistant Secretary Edgar Galvante with Attorney Mercy Jane Paras Lanes. From the Department of Labor and Employment, we have Director Marco Antonio Valeros, Engineer Melanie Banayos, Engineer Dennis Aquino, and Ms. Queen Espinas. From the Department of Justice, we have State Counsel Francesco Benson Anbochi and State Counsel Maria Doris Visuralta Garcia. From the Bangko Sentral ng Pilipinas, we have Ms. Ellen Joyce Suficiencia, Attorney Marie Tanya Recalde, Mr. Jade Eric Gredoblado, and Attorney Carissa Bianca Borlagdan. From the National Economic and Development Authority, we have Mr. Richard Emerson Ballester, Attorney Renz Mark Garcia Sr. From the Construction Industry Authority of the Philippines, we have Assistant Secretary Noel Prudente and Mr. Jeremy S. Marquez. From the Construction Industry Arbitration Commission, we have Attorney Catherine Josephine de la Cruz. From the Philippine Constructors Accreditation Board, we have Attorney Herbert Matienzo. From the Philippine Overseas Construction, we have Ms. Doris Gacho. The Philippine Domestic Construction Board, we have Engineer Liberito Espiritu. From the private sector, we have from the Association of Carriers and Equipment Lessors, Mr. Eladio Angeles, with Mr. Jonathan Perez and Attorney Genesis Adarlo. From the Association of Vehicle Importers and Distributors, we have Mr. James Gonzalez and Mr. Michael Ermita. From the Chamber of Automotive Manufacturers of the Philippines, we have Attorney Romel Gutierrez.
Morning.
From the Development Bank of the Philippines, we have Mr. Rustico Noli Cruz. From the Philippine Constructors Association, we have Mr. Wilfredo Dicena, Mr. Ibarra Paulino, Mr. Leo Valera. From The Philippine Sugar Millers Association, we have Attorney Jesus Barrera, Mr. Oscar Cortez, and Ms. Jana Vicente. From the Rural Bankers Association of the Philippines, we have Ms. Elizabeth Carlos Timbol. From the Top Gear Philippines, we have Mr. Nikita Mayo. We also have technical consultant and former finance secretary, Mr. Margarito Teves. We also have from the Laban Consumer, Mr. Mario Di Magiba.
Good morning.
Sir.
You're done,
Yes,
Comsec?
sir. Yes, sir.
Okay. So, ladies and gentlemen, we have scheduled to hear today, ba to? 1, 2, 3, 4, 5, 9 measures. Okay, referred to our committee. But actually, this can be subdivided into around 5 topics. Okay, so the Used Car Lemon Act, that's one topic. The amendment of the Philippine Lemon Law is another topic. The Heavy Equipment Registration Act, third topic. And then amending the R.A. 4566 or the Contractors License Law, there are 3 measures on that, on that topic. And then the last topic would be 3 measures also on the Warehouse Receipts Law of the Philippines. Okay. So allow me to modify our flow, the agenda flow, because I could see Congressman Dong Gonzales here with us, and Senator Lapid is also here with us, and they are, I am sure, they are here for the bills amending the Contractors Law or the Contractors License Law. So if there is no objection from our resource persons, unahin na po natin ito. Okay? Ako na mismo mag-sacrifice. I have my own bill, pero unahin ko na po ito because we have a guest from the House of Representatives. So, okay, I have assigned my staff, Attorney J. Kerubin, to give us the a brief description of the essence of the said bills. Si Attorney Kerubin, please go ahead.
Yes, sir. SBN 1809, SBN 2091, and House Bill 7808, all amending the Contractors License Law, seeks to promote competition in the industry and also update or change the penalties and fees of the current law to make it applicable to the present rents. It also adjusts the validity of licenses to respond to the call of the industry players.
Okay, thank you, Attorney Kerubin. Siguro, I will give the author in the Senate, muna Senate, and then the author in the House sometime to give opening statements. So if they are so minded. So Senator Lito Lapid, sir, this is one of your bills. If you want to make an opening statement, I am now recognizing you.
Yes, sir. Magandang umaga sa committee na chairman ko, Pimentel, napakasipag. Lagi tayong nakikita rito. At sa aking mga kapwa senador, mga resource person, salamat po sa pagtalakay ng Senate Bill 2091 na mag-aamenda sa Contractor License Law Republic Act 4566. Meron ako opening statement na susumite sa i-insert ko na lang po sa record. Salamat po. At last ko lang iparating na itataas ang penalty ng mga illegal na gawain, mga pangungontrata mula sa 500 piso hanggang 5,000 piso. Tataasan natin ng 100,000 hanggang sa kalating milyon. At hindi na rin lilimitahin ang filing ng at renewal ng mga lisensya ng Hulyo at 30 ng katapusan na buwan, taon-taon, upang hindi magsiksikan at maghabol sa deadline na ito. At ang buhay ng lisensya ay gagawin mula sa araw ng maaaprubahan. Magbibigay ito ng mahabang buhay sa lisensya ng mga kontraktor na may mga good standing, depende sa kanilang laki. Yun lang po at maraming salamat. Magandang umaga.
Salamat po, Senador Lapid. So, who else among the senators? Kung wala na po, I will now recognize Congressman Dong Gonzales. Kong, if you want to say something. Please unmute. Ayan, Congressman.
Thank you, Mr. Chairman, Chairman Coco, and of course to my kabalin for supporting this bill, Senator Lito Lapid. Mr. Chairperson, distinguished colleagues, ladies and gentlemen, good morning. Simple lang po ang proposal ng House Bill number 7808, mga probisyong administratibo lamang at aking inamen. First, nasabi ni Senator Lapid, to raise and impose fines for unlicensed contractors. Second, to increase the amount of application fees have remained unadjusted to inflation since 1965. And third, to amend the license renewal process to make it easier and more flexible. The need to impose higher fees for licensing, registration of application and renewal will address inflation in rising operational costs and expenses of the PCAB. Dagdag pa ito sa kanila. Makakatulong din po sa pagtupad ng kanilang mandato, sa kanilang pagbibigay serbisyo, at iba pang proyekto na may kinalaman sa pagtataguyod ng advokasya ng Philippine Contractors Accreditation Board. Higit sa lahat, ang panukalang batas na ito ay makakapagbigay ng kinakailangang tulong sa mga local contractors na patuloy na naghihikahos dulot ng epekto ng COVID-19 pandemic. Mr. Chair, the construction sector is meant to be a key driver in economic revival. In fact, the 2021 GAA allowed 1.1 trillion pesos for public infrastructure, which is expected to support some major flagship projects under the mantra of the President, the Build, Build, Build program in recent years, Mr. Chair. The construction industry has recorded the highest growth rate among the industry sector, not only as it contributed to overall capital investment in the country, but it had also one of the highest shares of total employment in the country. Let us provide and level the playing field in eradicating these unlicensed contractors. So, Mr. Chair, bago po natin pag-usapan yung mga komplikadong issue siguro ng pagpasok ng mga dayuhang industriya, linisin po natin ang sarili nating bakuran. Pagtibayin ang batas to keep up with the current standards at palakasin at i-develop ang kakayanan ng local contractors upang makasabay sila sa kompetisyon sa pandaigdigang merkado. Hinihingi ko po ang inyong suporta upang maipasa po ang panukalang batas nito. Mr. Chair, maraming salamat po sa inyong lahat. Magandang umaga po.
Thank you, Congressman Gonzales. Okay, siguro the logical government agency to react to these bills would be the DTI, to which is attached the Construction Industry Authority of the Philippines. Tama ba ako? CIAP, are you present? Senate, who do we have?
Yes, Mr. Chair.
Yusek Prudente and Jeremy? Yeah. Okay, anyone from the...
Good morning, Mr. Chairman.
Yes. Yes, sir. Go ahead. Sino po to? Wala kayong video, sir, no? Who wants to be recognized, please, from DTI?
Good morning, Mr. Chairman.
Okay. Yes, go ahead, sir. Mr. Prudente.
Good morning, Mr. Chairman. We are CIAP. Good morning, honorable members. And CIAP is support together with our mother agency in the passage of this bill, Mr. Chair.
Sir, nakamute kayo. Are you done with your manifestation?
Yes, Mr. Chairman.
Okay, ano bang ano, how will this bill change what is currently being done? Penalties lang or meron bang ibang pagbabago tayong mararamdaman?
Mr. Chair, if I may, I am the director from PCAB. If I may be recognized, sir.
Mr. Matienzo?
Yes, sir. Chairman,
Okay.
good morning po.
Saan ka ba? Okay, yes sir. Okay, sige. Pickup. Yes.
Good morning, sir. On behalf of the PCAB, sir, and SIAP, we fully support the measures introduced by Senator Lapid and Congressman Dong Gonzales. As regards, sir, the effects of this bill, sir, this will definitely change the landscape with regard to the renewal of licenses. If you will notice, sir, in the current bill, every license expire all at the same time at June 30. And with the passage, sir, of the Ease of Doing Business Law, we could not possibly process it on time in accordance with the periods provided for in the Ease of Doing Business Law. And this will truly help us, sir, and will change definitely the landscape with regard to our service to the public, to the contractors themselves, making us more effective and efficient, sir. So we welcome this measure, sir, and hopefully this gets approved the soonest possible time, sir, especially now that we're still in the pandemic and we're still following the health protocols issued by the IATF and this government. So definitely, sir, we welcome these measures and we hope that these measures will get its approval, sir. Salamat po. Maraming pong salamat, sir.
So, a question, all licenses expire on June 30. Oh,
Yes, sir.
You cannot change this by regulation. Okay, the chair recognizes the presence of Senator Kiko Pangilinan. Senator Pangilinan, just interject whenever you want. We're talking about the contractor's license. So all expire on June 30. So you cannot change the expiration dates by mere administrative issuance?
No, sir. Unfortunately, it's we cannot do that, sir. It's explicitly provided, sir, in R.A. 4566, sir.
By
That
law.
all license by law, sir, it's provided, sir.
The validity period of the licenses are these all for 1 year or katulad na rin nung nasa bill na if you are in existence for 10 to 25 years, iba ang validity, mas mahaba. If more than 25 years ka na in existence, mas mahaba din yung validity. Yung concept na yon, is that in present law o wala?
Wala po siya, sir, sa present law natin, sir. Every license, regardless of their years in operation, all expire on June 30 and every year po, they need to renew.
Oh, so maganda ba yung concept na yon? Yung
Yes, sir.
sige.
Yes, sir. Yes, sir. Yes, sir.
Kasi parang may track record na no?
Yes, sir. Yes, sir. They have provided a good track record. They have good standing. So we can presume and assume that they will continue to be in good operation for the next 2 or 3 years in accordance with what is going to be passed by the Senate and the Congress, sir.
Okay, pero siguro yung fee nung longer validity period iba doon sa 1 year. Parang ganun ba? Okay, ganun ba
Yes,
yan?
sir. Yes, sir. Ang nabasa po namin, yung kung 3 years yung validity, will have to pay 3 years in advance for the application for renewal, sir. So that is also, that will not hamper, sir, our collection, even if they will have to renew 3 years after or 2 years after, as the case may be.
Okay, so how about si E.D. Marquez, you want to say something of CIAT?
Mr. Chair, I just want to say we fully support like what PCAB E.D. Matienzo said.
Can you, for my education, how is PCAB related to CIAP?
Sir, under 1746, sir, the presidential decree basically put PCAB under SIAP or creating PCAB under SIAP, sir. So PCAB is an implementing board under the Construction Industry Authority, sir.
Okay. Sige. For focus siya for accreditation lang of contractors.
Yes, sir.
Okay. So ito pala, this is very specific this is PCAB's concern. Yung nabalitaan ko ngayong umaga, the very sad news na may namatay sa demolition of building. Kailangan ng yung contractor ba to demolish a building, kailangan ng license?
Yes, sir.
Tama. Yan ang nasa
Yes,
bill.
sir. Yes, sir.
So ano nangyari rito?
Sir, I'm sorry, sir, but I have yet to read the papers or news about that, sir. But definitely, sir, we will investigate that matter, and the necessary sanctions such as removal or revocation of their license will be handed to them, sir.
Tatlo patay. Yun ang narinig kong balita. Very sad news. Demolition ng building. Pero anyway, so any other matters or any other comments? So how about the do we have a contractors association, yung players in the industry present?
Yes, Mr. Chair.
Oh, you want to say something? Who is representing them?
Can I acknowledge, Mr. Chair? Will Desena of PCA.
Mr. Desena, yes, go ahead.
Thank you, Mr. Chair, and good morning to everyone. For House Bill 708 of Congressman Dong Gonzales and House Bill, Senate Bill 2901 of Senator Lapid, we don't have comments, Mr. Chair. But can we have some comments on Senate Bill 1809 of Senator Bong Revilla? Because it's not been introduced yet.
Yes, sir, kasali po yan. One of the 9 measures po yan. Yes, go ahead.
Thank you, Mr. Chair. Regarding House Bill 1809 of Senator Bong Revilla, we don't have comments on the amendment of Section 9, 23, 35, 39, and 40 of RA 4566, and also some insertions. But however, our concern is more on the provisions of the reciprocity clause on the 3rd paragraph, which this must be carefully reviewed, because while some countries claim that their markets are open to Filipino contractors, and that is not the reality on the ground. Clear laws of engagement should be established first before granting reciprocity in order to afford foreign and local players a level of playing field. Government must assure that whatever incentives and privileges extended to foreign contractors are likewise given to local contractors. Correspondingly, foreign contractors should comply with whatever regulatory requirements, such as basta divided to payment of unnecessary taxes, putting up of equity and structural warranties for materials, manpower, and equipment required for local contractors. And also likewise, we recommend to strengthen enforcement of regulations, Mr. Chair.
So, thank you. Just for the record, no, we are now discussing the Senate bills numbers 1809, 2091, and then House Bill 7808 referred to the Senate. Okay, parang klaro. So all the 3 measures. Tama ba yung number, Kong Dong? The House Bill number. Tama, okay. Okay, so very good input, because the Revilla bill mentions reciprocity, but ang nakukuha ko, sir, Mr. Desena, you want an elaboration of what this reciprocity requires?
Yes, Mr. Chair. Yes, Mr. Chair.
Okay, hindi po ba PCAB, please react. Hindi po ba, let's say I'm a foreign-owned contracting entity, hindi po ba dadaanan din ng PCAB yung all my capabilities, all of my all of the other requirements, and then you will be as strict on the foreign contractor as with the Filipino contractor? PCAB,
Thank you for the... Sir, yes, sir. Foreign contractors are also regulated, sir, by PCAB, in the sense that they are being granted a special licensor. A special licensor is project-based. So if for every project that foreign contractors may wish to participate, they need to apply for an individual or a separate special license. But with regard to the measure introduced by Senator Bong Revilla, sir, it totally eradicates or removes the distinction between the regular license and the special license because from what I read from the Senate bill, sir, it will now allow regular licenses to foreign contractors, sir. For the information of everyone, sir, for regular licenses are being issued to Filipino contractors or those following the 60%, 40% arrangement, sir. And yun po ang ginagamit. But nonetheless, sir, foreign contractors are still allowed to obtain special licenses from PICAB via the special license in joint venture or consortium with local contractors, or if the projects to be participated by this foreign contractors are classified under PPP, International Competitive Bidding, Build, Operate, Transfer, or when the government agency concerned, procuring entity concerned, establishes that there is an inadequate supply of Filipino contractors to do such projects.
Mr. Chair, I add, Mr. Chair.
Sige, go ahead, Mr. Dicena.
Especially kasi sa reciprocity, PCA is a founding member of IFAOCA, Association of 18 countries for almost 70 years. IFAOCA is an International Federation of Asian and Western Pacific Contractors Association and also a founding member of ECF, ASEAN Contractors Federation. And our experience with them is, well, of course, they open the market. Kaso nga lang po, especially yung mga regulations nila, one classic example is may mga examinations na yung exam is doon sa dialect nila that you cannot understand. So, simply to say, huwag ka na yung pumunta dito kasi definitely babagsak ka doon sa yung mga regulations nila. So, as simple as that. Mr.
Okay,
Chair.
pero very good input yan from experience. Pero depende rin sa sinabi ng konstitusyon nila what their official language is, di ba? I mean, sa atin kasi sa konstitusyon natin, it's Filipino and English. So, mag-adjust sila up to that point, Filipino or English. So, can I ask PCAB again? What are you doing now? In light of the Supreme Court case, there is a Supreme Court case, sir, di ba?
Yes, sir.
So how did the Supreme Court case or decision change your procedures or what you have been doing?
Sir, relative to the decision of the Supreme Court, the Office of the Solicitor General filed a motion for reconsideration sometime in August of 2020. And several petitions for interventions were also filed by accredited associations like PCA, Davao Contractors Association, Cebu Contractors Association, NACAP, and all of which are still pending with the Supreme Court. So until such time, sir, that the Supreme Court has issued a decision which is final and executory, nothing has changed, sir, with regard to the issuance of licenses. But nonetheless, sir, we still issue special licenses to foreign contractors. They're still able to participate in all of our procurement activities, provided they are qualified to join, sir. So with regard to the decision, sir, of the Supreme Court, it has yet to affect our operations, our issuance of licenses, because the same has not yet reached its finality, sir, in the Supreme Court.
Okay, so that's a good reason pala. Hindi pa pala siya final and executory. So the rule now is foreign contractor special license on a project to project basis yun. One
Yes, sir.
project license, one project, one special license.
Yes, sir. Yes, sir.
Okay.
Mr. Chairman, Mr. Chair,
And the Revilla bill changes the rule if this becomes law.
Yes, sir. If I may add also, sir, to allow the entry of foreign contractors to be issued a regular license, we introduced a quadruple A license sometime in 2016. With a capitalization requirement of 1 billion pesos only, and that the project that they should enter into are private funded projects amounting to 3 billion or 5 billion as the case may be, sir. Unfortunately, it's only around 7 to 8 foreign contractors who availed of this measure, which we introduced in sometime in 2016, sir.
Oh, what was your legal basis in introducing this in 2016?
Sir, it was introduced in 2016 by the the SIAP board, sir. I was not yet present that time, sir. It was introduced in 2016 to to allow foreign players to big ticket projects in private funded projects, sir. We must take note, sir, that under Republic Act 9184 or the Government Procurement Law, it still prohibits participation of foreign contractors in locally funded projects, sir.
Mr. Chairman, can
Oh,
it be allowed to...
yes, sir. Please, Mr. Espirito? Yes, sir.
Yes, Philippine Domestic Construction Board Chairman, Mr. Chair. In 2016, we initiated through the SIAP, the Construction Industry Authority of the Philippines, the approval of the regular license with annotation, and that allows wholly owned Filipino or foreign contractors with a net worth of at least 1 billion pesos to come in. And right now, we have almost 32 contractors, local and foreign contractors who have been granted this regular license with annotation. So this provides a level playing field for both the local and foreign contractors to come in, wherein the specific rules of engagement are specified here, and that is what we are also trying to explain for the entry of foreign contractors coming in under the level playing field under the reciprocity principle, Mr. Chair.
Thank you, Mr. Espirito. Thank you for that. So, who else wants to comment on the three measures that we are discussing?
Mr. Chair, good morning.
Mr. Ballester, yes, sir.
Yes, sir. Good morning. This is Mr. Ballester of NEDA. We would like to give our comments, Mr. Chair. Thank you for inviting NEDA in this joint public hearing. Indeed, construction, Mr. Chair, is one of the vital industries of the Philippines. From 2011 to 2019, it grew at an average of 11.7%. It had an average employment generation of 244,000. It has an output multiplier of 2.27 pesos, meaning, Mr. Chair, for every 1 peso that you spend, you'll be able to have a return of 2 pesos and 27 centavos. So NEDA generally supports the proposed amendments as the changes are expected to promote a more open sector and will provide a healthier growth of the sector. In turn, this will help boost the domestic economy. Our comments, Mr. Chair, cover 5 areas in the proposed bills. First, Mr. Chair, is on the eligibility to practice construction contracting. The first paragraph is already sufficient to declare that there is no nationality requirement to get a license on the practice of construction contracting. However, to ensure that the second paragraph is consistent with paragraph 1 and should not serve as a barrier to entry, the criteria to be set by PICAB for foreign contractors should be one and the same for Filipinos. This will ensure that participants in the industry are in a level playing field. It is also suggested that the criteria be published in all relevant government websites for transparency. When it comes to reciprocity, a clarification is requested on the purpose of the reciprocity condition in the practice of construction contracting in the Philippines. It may be noted, Mr. Chair, that the reciprocity condition serves as an additional barrier for FDI in the construction sector, which may be counterproductive to government initiatives to attract investments in the country. Nevertheless, if reciprocity shall be pursued, it is suggested that the third paragraph be restated such that reciprocity is flexible and the additional requirements are more beneficial to the country. We have here, Mr. Chair, suggested our wordings, and this will be included in our official submission po. Now, when it comes to penalties, the section in the proposed bills stipulating the methods or process how these proposed fines and fees will be updated may be included. Alternatively, this methodology can be reflected in the IRR once the bill is passed into law. Considering that the purpose of RA 4566, among others, is to ensure for the safety of the public that only qualified and reliable contractors are allowed to undertake construction in the country, more stringent sanctions and monetary penalties could be put in place. Along with this, the Uniform General Conditions of Contract for Private Construction, prepared by the SIAP and its key stakeholders, could serve as a reference in establishing the said penalty sanctions. On the penalties under individual license, Mr. Chair, this section may be placed instead under Section 35 along with the previous penalty provisions. This suggestion also applies to the proposed amendment on section on joint licenses. On fees, using the CPI, we have a base year of 2012. The proposed fees for obtaining an original license examination of an applicant and annual license renewal are approximately close to the proposed values in the bills. Estimates show that in full year 2019, the fee for the original license and the annual renewal license should be at 4,496 pesos, while the examination of an applicant will cost around 5,395 pesos. However, the increase of 5,000 pesos in licensing fee across all categories may impact small firms the most. This belongs to category C, D, and E. It is suggested to reconsider the methodology used in increasing license fees as proposed in the said bills for Section 39. For example, a percentage may be used instead of specifying the amount for the increase in the fees. This will support small contractors in the industry, especially during this time of pandemic. On a side note, Mr. Chair, the categorization fee makes up a substantial portion of the cost paid by applicants. So, based on what we have seen in the website, it's between 46% to 92% of the total license fee. It is noted that the fee structure may be modified through PICAB board resolutions. Thus, it may be clarified whether the imposition of a fixed fee in the law would mean that PICAB may not change the license fees in accordance with the needs of the industry. Alternatively, the subject bill may provide the parameters on which PICAB shall base any changes in the amount of the fees imposed to provide a regulator with the needed flexibility. This should be coupled with an additional provision in the law that PICAB may fix the fees from time to time through its regular issuances. While the adjustment of fees can be justified due to the need to update them for their present values, it must be ensured that an optimal balance is incorporated in these proposed fees. This means that the increase in fees have to be justified by the corresponding benefits to the construction industry. On processing fee and registration fee, currently, the application fees are paid in full and are non-refundable. Considering that application fees are relatively higher in the Philippines than in Singapore or Malaysia for large contractors, a two-step payment scheme may be considered similar to Malaysia, wherein a processing fee, which is the minimal amount, is paid initially, and upon approval of the application, the fees or the firms are requested to pay the registration fee. This could attract applicants as the monetary risk to contractors is minimized. The last one, Mr. Chair, is on the renewal of license. The extended, flexible renewal period and license validity of good standing vis-a-vis length of service of the contractors, as indicated in the Bills 2091 and 7808. This could serve as an incentive to encourage contractors to provide quality service. More importantly, this could lessen the administrative burden on the government and on the contractors. It is recommended, however, to add provisions in the law that the grant of licenses with extended period, contractors shall be subjected to a regular randomized audit conducted by the appropriate accreditor body. There is also a need to reconsider the operationalization of a system which allows for automatic renewal of license for firms with good standing. Such procedural adjustments are deemed in line with the ease of doing business. It is, however, important to note that PICAB recently launched its online renewal portal and reduced renewal requirements from 24 to 9 as announced in their website. Allowing the renewal of licenses via online is also in line with the move to digitalize government processes under the new normal. However, what merits a good standing, what criteria will be used for a contractor to be considered as such needs to be clarified. Those are our comments, Mr. Chair, and we will send the official comments once this has been cleared by the Secretary. Thank you very much, Mr. Chair and members, honorable members of the committee.
Mr. Chair.
Thank you, sir. Thank you, Neda. Yes, Congressman Gonzales.
Mr. Chair, the way I look at it, House Bill 7808 and Senate Bill number 2091 is merely administrative po, no? Kasi this only a local contractors renewal. And we have a pending bill in the House of Representatives regarding this foreign. I think we can separate this issue po sa aming proposed House Bill and proposed SB ni Senator Lapid. Kasi I think this is a different discussion, this is a foreign. Pwede nating i-match to sa bill niya, Congressman Gatchalian, the Deputy Speaker, para mabigyan lang ng katugunan itong aming. This merely administrative lang po kasi yung amin. It's only a renewal, Mr. Chair. Thank you po, Mr. Chair.
Thank you. So, kasi yung isa introduces a new concept which is also being debated or litigated before the Supreme Court, di ba? So, depende natin. So, ang isang purpose po nito mga bill natin, yung mga penalties para po malinis ang ating mga yung larangan ng ating mga contractors. Bakit gaano ba kagulo, Pickup? Ano bang situation on the ground? Marami bang mga unlicensed contractors diyan na gumagawa ng mga kilos o activities na kailangan pala ng license? Can you tell this committee what is the situation on the ground?
With regard to the penalty, sir, as mentioned in R.A. 4566, we can only impose the maximum penalty of 5,000 pesos, sir. So ever since, sir, hindi po nabago yan from 1965. As regards unlicensed contractors, sir, in 2018, we got data from DILG, sir, that around 45,000 mayor's permit and business permits were issued nationwide to contractors. But at that time, sir, we only had 12,000 licensed contractors, sir. So we're missing around 30 to 33,000 contractors, sir. This is despite the Joint Administrative Order 2011 issued by DTI, DILG, DOLE, and SIAP that mayor's permits or business permits could not be issued to contractors applying for business permits or mayor's permits without them showing first that they have obtained a valid PCAB license, sir. So if this measure will be approved, sir, definitely, sir, we can expect an increase of number of licensed contractors. Plus, sir, we will be giving more teeth to PCAB because, sir, tataas po yung aming penalties that can be imposed. Kasi, sir, let's admit it, what is 5,000 to unlicensed contractors right now, sir? Masyado pong mababa po, sir, yung amount that can be imposed to those that we are apprehending, sir, for operating without a valid PCAB license.
Mr. Chairman?
Walang imprisonment pala?
Wala, sir. Wala po.
Kita ko fine lang siya, no?
Opo.
Okay, which we are not changing. We are not changing the concept. It's still a fine, di ba?
Yes, sir, but I believe, sir, that providing a higher fine can somehow, sir, change the landscape po with regard to unlicensed, to the operation of unlicensed contractors, sir.
The mere fact na yung number of permits at the local government level is more than the number of licenses you issued, yun ba yung conclusion doon na maraming unlicensed contractors, or pwede ba yung one licensed contractor is getting more than one LGU permit?
Ay, sir, that can happen, sir, but hindi lang po yun ng aming ano po, sir, hindi lang po yun ang aming barometer for concluding such, sir, because we receive a lot of complaints, sir, from the public complaining about certain contractors, and that not more siguro, sir, ang statistics po namin 7 out of 10 po na nireklamo sa amin, sir, wala pong mga lisensya, sir.
Mr. Chairman,
So,
can I add?
Masyado nga siguro walang ngipin. One more question na lang. A licensed contractor needs to get a permit from the LGU. But is a permit issued by one LGU valid for this contractor to also operate in another LGU?
Yes, sir. I believe so, sir, because the license itself, sir, does not limit your operation in your particular area where you were registered. In the sense that even if you're based in Makati, you can do projects in Mindanao so long as your means permit to do so.
Main office mo. Main office yun.
Yes, sir.
Yes, Congressman Gonzales, please. Dong, nakamute ka.
Mr. Chairman, in addition with Attorney Matienzo, PCEB, kanina po nasabi nyo na may gumuhong building sa atin. Yung sinasabi natin magkaroon ng mga subcontractors, yung lisensya. In Republic Act 9184, bawal po yung subletting. Ngayon, yung mga nagsasublet po yan, yung GenCon ang nagbibigay ng papasubcon. Ang sinasabi po natin, kailangan yung mga nagsasubcon, pwede na rin po sila kumuha ng contractor's license. Kasi like for example, electrical, mechanical, etc. Yung mga labor, yun po yung sinasabi natin na walang lisensya talaga po yan. Kaya pag may nangyari sa isang building, ang nananagot po ang GenCon. Yun ang sinasabi ni Atty. Matienzo. Wala po silang contractor's license, na nakakuha ng big ticket, and then there is a subletting. So, wala po silang lisensya. Kaya yun po yung sinasabi natin, sana magkaroon ng lisensya, Mr. Chair. Thank you po.
But, teka, tine-check ko yung ating bills kung na-require ba natin yun, Kong. Kasi we are focused on penalties here So,
sir, nonetheless, sir, it's written po na even subcontractors needs to get a pickup license, sir.
Under existing law.
Yes, sir. Yes, sir.
Tama naman yun, tama. That's logical kasi specialized yung trabaho nila, right? Ano ba to? Mga electrician, ano pa? Ano example, Director?
Electrical works, sir, mechanical works, yan po yung mga navigational facility, communication facilities. These are among the specialty works that are being licensed under pickup, sir.
Mga plumbing, hindi?
Kasama po, sir, ang plumbing. Even painting services, sir.
Even painting, kasi...
Right now, sir, we also introduced the solar power installation, sir. They are also being licensed.
Tama.
Because of the emergence of the renewable energy sector, sir. So we are also licensing those disciplines po.
Mr. Chair, can I comment?
What do you call the license that you issue, Director?
Sir, they are still regular licenses, sir, but under their license specified po yung specialties that they can do and they are required to do under the license.
Okay, but you refer to this as regular licenses, nandun lang.
Yes, sir. Yes, sir.
Okay. Who wants to be recognized?
Mr. Chair, can I?
Mrs. Espiritu, yes.
Yes. In relation to the statement of Picab E.D. Matienzo, the CIAP has initiated a joint administrative order involving all the local governments and municipalities, particularly the building official under the DPWH, for the issuance of building permits and all other permits only to licensed contractors to be able to monitor and to penalize contractors who are not licensed, because contractors who are licensed have structural warranties. So yung sinasabi ni the Honorable Congressman Gonzales about yung building na gumuho and so on, minsan tumatakbo yung contractor because they are not they are not liable and accountable to the structural component of the building. So if they are licensed contractors and even licensed subcontractors, then they will be held accountable for whatever defects of certain structures in the country. So very important, Mr. Chair, yung Joint Administrative Order para lahat ng local governments through the building official will be able to really control na yung mga permits na ini-issue nila talagang licensed contractors lang. And that will eliminate the existence of unlicensed contractors who are malaking percentage nito, Mr. Chair, in the country. Yun lang, Mr. Chair. Thank you.
Thank you, sir. Who else who wants to comment on the three measures? Meron po ba?
Mr. Chair.
Sino to? Jeremy? Mr. Marquez?
Yes, sir. Sir, actually, as you know, bago lang po ako dito sa SIAP, and we have been reviewing the SIAP mandate, the Presidential Decree of 1746, sir. And I want to take advantage na nandito po yung mga sponsors from Congress and of course the Senate to give a clarification on the matter of amending 4566, sir. No? So if you let me state under Section 4 of PD 1746, if I may read, the Philippine Contractors Accreditation Board is hereby created under the jurisdiction and supervision of the authority. The Philippine Contractors Licensing Board is hereby abolished and all its funds and records are hereby transferred to the PCAB. Under the same section, sir, item B, the functions of the Philippine Contractors Accreditation Board shall perform the present function of the Philippine Contractors Licensing Board until such time as its other functions and powers and duties are issued by the authority. Sir, my question here is, sir, kasi we are under the process of amending the SIAP IRR. And although we are in full support of the proposed amendments to the 4566, my question here is, will the amendments, if approved, sir, will this change the mandate given to us by 1746 or PD 1746, giving the authority the power or function to give PCAP such amended jurisdiction or function, sir?
Give me time to consult with my staff if they got the essence of the question. That's a very old law you're citing, no, Jeremy?
Sir, the PD 1746 basically created SIAP, which is actually a later law than RA 4566, sir. So my question is, kung ma-amend yung 4566, will this supersede PD 1746, sir? But PD 1746 basically said i-dissolve na po yung creation of the Philippine Contractors Licensing Board, which created PCAB, sir. So in my layman's point of view, sir, it actually maybe repealed or superseded RA 4566 already.
Okay, so we will take note of your manifestation at pag-aralan natin yan kasi tandaan mo na every new law will now contain this repealing clause where there is yung express, sometimes there's express repeal, sometimes there is implied repeal. So aralin natin na mabuti yan, and then if we need to expressly repeal existing provisions of law or some provisions which we may think still to be existing, just to be very clear, gawin natin yun. Doon natin ilalagay. Oh, okay, so but thank you for pointing that out. Hindi lang kita masagot ngayon kasi wala sa akin yung mga records eh. So basta at least you pointed that out.
Opo, sir. Para din alam din namin, sir, for future reference, na if CF is still capable or still has the power to give such other functions to PCAP, sir. Like I said, sir, nasa IRR amendments kami ngayon, and we're reviewing all of the sections under the CF IRR.
Sige, but
Thank you, sir.
but focus on the subject matter of the bills that we're talking about, more or less nasa ano lang tayo, nasa adjustment of the fees and the penalties, more or less, yung
Yes, sir.
yung dalawa. Okay, so okay, ganitong lumalabas, no. I will explain to Senator Revilla, although nag-overlap kasi yung bill niya sa subject matter of the LAPID and the House bills, but as far as the expressly allowing foreign-owned contracting agencies to operate by law, i-defer muna natin yan. Okay, but the main points of the LAPID bill and the House bill on adjustments of fees, penalties,
Renewal.
and then the renewal, and then the validity period of those contractors who have track record, i-retain po natin yon. Unless is there any objection to the concepts that we mentioned? Wala naman po. Sige, but can I now ask all of the government agencies here present as well as the private sector stakeholders to submit your position papers on the said bills, including the Revilla bill, including on the matter of reciprocity, para meron na po kaming preview on your stand on the issue. Kasi sooner or later, we will also act on that. And we will not allow the pendency of the Supreme Court case to stymie the action of Congress. Kasi if we can do it by law, then we will do it. Also, it's not a question of constitutionality na yata ngayon. Or is it, Mr. Matienzo, ED? Is it a question of is the question a constitutionality?
Yes, sir. It's a question of new constitutionality of the imposing of the nationality requirements.
So you mean to say those who filed the MR claim that their position is that foreigners cannot be allowed to be contractors? Ganun ba?
Sir, no. The position is that Section 3.1 of the IRR of RA 4566 is constitutional, sir, in imposing the 60-40 requirement for the regular licenses, sir.
Oo nga, 60-40. And then because you based it to under what 60-40 rule did you base it on? Found in law or found in Constitution?
In the Constitution, sir, because the framers of the IRR based such under the Constitution which protects yung pong patrimony, and yun nga po, also with regard in accordance with the letters of instruction 630 Commonwealth Act po, tagal na pong batas doon po sa pag-impose po ng 60-40.
Okay, sige. Anyway, that's pending before the Supreme Court, but the Congress can also make its own determination.
Yeah.
If we believe that we can allow it by law. So in the meantime, basta ganito nga ang the result of our hearing today is we will now focus on yung House bill muna and the LAPID bill, yung subject matter nila, confine our subject matter to the subject matters of the said bills. Defer action on the reciprocity requirement because we will defer action on on whether we should allow foreign contractors to undertake work here in the Philippines. Defer muna, but your position papers can already touch on this subject matter. Okay, sir? Okay ba, Mr. Dicena? Okay kayo, sir? Mr. Espiritu?
Yes, Mr. Chair.
Yes, okay kami, Mr. Chair.
I agree. Thank you.
Okay, so any other comments? We will now move on. So okay, so
Mr. Chair.
okay, so meron pa, sige. Yes, the Department of Justice, Mr. Anbochi. Yes, sir. State Counsel.
I would say, yes, Mr. Chair. Mr. Chair, I would just like to flag yung kay Senate Bill number 1809, Section 3. This is for practice, construction, contracting. This will do something huge. Reading of the RA 4566 uses the phrase engage in the business as a contractor, which is different from the practice from practice construction contracting. We would just like to flag this because Supreme Court case already provided or ruled that being a licensed contractor does not automatically qualify within the ambit of the Constitution as a profession per se. So for consistency and avoid confusion, it is suggested that the term engage be used instead of this in terms of that provision provided in the Senate bill. That's all, Mr. Chair.
Okay. State Counsel, sayang medyo choppy po yung signal nyo. But can you submit for and on behalf of the DOJ a position paper on this?
Yes, sir.
Kasi medyo choppy, sir, eh. Unless ako ba yung choppy? Ako siya.
We will submit the position paper. Yes, Mr. Chair.
Sige. But
Yes, Mr. Chair, we will submit.
okay.
Okay, po,
Thank you, sir. Thank you. Thank you, sir. Thank you. So any other
po, sir.
comments?
We will submit, sir. Thank you.
Thank you, thank you, thank you. Any other comments on the three bills that we have been discussing, three measures? So kung wala na po, we will now endorse to the plenary the substance of the Lapid bill, the Revilla bill minus the foreign contractors participation, and as well as the House bill. Are you the author, Congressman Gonzales, of the House bill?
Yes, I am the author, Mr. Chairman.
Oh, congratulations, sir.
Thank you, Mr. Chairman.
Bakapan ka namin, sir. Bakapan ka namin, sir. Okay. Thank you. Thank you very much. Thank you to all of those who participated for these three measures. Let's now move on. Can we move on? Okay. Can we move on now to Senate Bill number 2046, amending the Philippine Lemon Law. Okay. Attorney J. Kerubin, please give us the essence of this bill. Yun muna, yung amendment of the Lemon Law for the brand new car sales.
Yes, sir. The bill seeks to amend and improve the current lemon law and seeks to reduce the number of repair attempts for new cars with defects to be given replacement. When a car has defect, which endangers the rider or the people outside the vehicle, it is mandated to replace the vehicle with a new vehicle. So this is the current for the amendment of the current Philippine lemon.
Okay, we have, I think, invited DTI, LTO, some association of vehicle distributors, etc., and the Laban Consumer also. Okay, so DTI, please. DTI, are you ready? Asek Kabotchan.
Good morning, Mr. Chair. Good morning to the honorable senators who are also part of this committee and to everyone. On the part of DTI, I come from the Consumer Protection Group, and the DTI will be submitting a position paper, but for us in the Consumer Protection Group, we support the passage of this Senate bill. We have noted, I looked at the statistics of our Fair Trade Enforcement Bureau. Although there is not a lot of complaints, we have seen the difference of those complainants in really being able to get their money's worth out of a purchase of a very expensive item. So I've noted that there have only been 39 since 2014 up to 2021, sir, on the lemon law. But we have been approached so many times with, of course, the requirements in being able to also invoke the lemon law provisions because it states 4 repairs, and then after the fourth time on the same complaint, then you would have to, of course, give your intent to invoke the lemon law provisions, and then a final repair is undertaken before, of course, that the manufacturer or or the dealer is going to proceed with the lemon law provisions. We note that under the draft revised Consumer Act of the Philippines, we would like to now institutionalize the United Nations guidelines on consumer protection, including the right to information, so that when consumers are make a very substantial purchase and even just in ordinary purchase, they should be well informed of course, the products, and those products that they purchase should also perform as they are really expected to. And we note that in the case of the lemon law, these vehicles do not perform as they are expected to. So, sir, we will be, of course, submitting our position paper on the part of DTI, but on the Consumer Protection Group supports this particular bill. Thank you, sir.
Mr. Chairman.
Yes, Kong
Mr. Chairman,
Gonzales.
can I be excused na po?
Yeah, yes,
Thank you
yes,
po.
yes, yes.
Thank you.
All resource persons who attended for the contractors license bills are already excused with that. With thanks from the chairman. Salamat po sa
Thank you,
pag-participate.
Mr. Chairman, for your support.
Salamat po.
Maraming salamat.
Thank you po. Thank you po.
Thank you po. Thank you.
Thank you, sir. Asek Kabotchan, what are the figures again? How many complaints connected with brand new vehicles or car sales po ang alam niyong umabot sa DTI, and how many were you able to resolve to the satisfaction of the consumer?
Sir, as far as the number of complaints, there are 39 since the lemon law took effect in 2014 po. There were some dismissals though, so yung resolved is 9. 9 were resolved. There was one that was archived, and there were others that, of course, were not resolved in favor of the complainant po. Because, of course, under the lemon law, it would show that if there were unauthorized repairs and other causes, that they could not invoke the lemon law.
Okay, so from 39 complaints, one was archived, but the 38 basta resolved. Basta not all in favor of the complaining party. Okay, that's okay. Basta na-resolve siya. Okay.
Yes, Mr.
And because if the complaining party wants to pursue it in court, pwede naman, di ba?
Yes, sir.
Yeah. So, do you know if they pursued in court?
I am not aware
Hindi
if
na,
they
no?
have pursued. Opo.
Okay, so how do you find the present procedure in the current lemon law? Is it too cumbersome for the complaining party? Yan yung purpose ko sana when I filed the bill to make it less cumbersome on the part of the complaining party, but still the decision maker, the referee or arbiter, will still resolve the issue objectively.
Right. Sir, if you ask me whether I find it cumbersome, well, it's really the requirements that are the major hurdles. Kasi po you are supposed to go through 4 attempts for the vehicle to be repaired before you can even invoke the provisions of the lemon law. For a brand new vehicle, sir, I do not think that uh, um, an owner should be going through something like that, because um, there are express warranties for the purchase of these vehicles. So I just think that the number of repairs is really of 4 repairs, and a final one once you invoke it is already, I think, too much for the consumer. So I guess it must be siguro reduce the number of times the repairs must be made. Kasi brand new po siya, Mr. Chair.
Uh, are you aware, ma'am, of lemon law versions in other jurisdictions in other countries? If meron man, how many attempts, repair attempts do they have?
Let me check, Mr. Chair, and we will include that in our position paper. So I
Thank you,
just want
ma'am.
to be sure. Yes,
Thank
sir.
you, thank you, Aseko. Any comments? Sino pa ba? Who did we invite? Yes, Mr. Tamayo, yes. Top Gear, Mr. Tamayo.
Yes, yes. I'd like to say that from what we've seen in other jurisdictions, other countries, uh, we can have a three-strike rule instead of a four-repair rule. And I was looking over the provisions of the Lemon Law and the proposed changes, the 1 month, 1,000 kilometer proposal for critical nonconformities for a full refund. And I think that one is a good idea, but it could be expanded probably to 5,000 kilometer or 6 months. Because typically anything that happens within the first 5 or 10,000 without any major damage caused by use would qualify under the Lemon Law. And I'd like to note that of the cases, sir, it has been helpful because I know of cases that have gone to arbitration that don't necessarily qualify as for repair, but since the manufacturers are conscious of the Lemon Law, they have gone to arbitration in good faith to resolve the matter with the customers. Pero the 4 repairs is a bit excessive, and the 12 month requirement, I think 3 repairs and possibly a reset of the timer for the second and third repairs might be sufficient, because there are certain vehicles that would have qualified under Lemon Law. I know people who've had 3, 4, 5 repairs of the same item, but over a span of 2 to 3 years, caused by the defect of the item, but they don't qualify generally under the Lemon Law.
But for sure that would have been a very unsatisfied consumer, hindi ba? Same item, time and time again, pinapa-repair niya. I mean, 'di ba
Yeah, well, the manufacturer.
parang unfair, 'di ba? Parang you did not buy a vehicle so that you will always be having it repaired.
Yes po. But the manufacturer made good on their warranty. To be fair, they made good on their warranty, and this was a known defect. It's not the fault of the local distributor. It's from higher up, from the global manufacturer. And the local distributor did make good on their warranty, and they did those 3 to 4 repairs in good faith without any cost to the customer. But at that point, by the third or fourth repair, you should be able to invoke Lemon Law. But since Lemon Law only covers like the first 12 months, kung sabihin mo yung third or fourth repair mo is after the second year or third year, and it's a known defect in the item and not caused by use itself, it should qualify. That's why I'm saying any revision to the Lemon Law should take into account this and maybe set a reset timer. For example, after the first repair, does it reset to another 12 months or another 8 months or another 6 months? After the third repair, is it another 12 months or 8 months or 6 months? It's something we should take into consideration because, for example, if your lemon, if your first defect only shows up near the end of the Lemon Law period, and then after that, sunod-sunod, every few months nasisira, that's something that will inconvenience the customer unduly within the warranty period, and then without it, they're left with nothing naman, no recourse. Pero like I said, to be fair to the distributors, these cases I know, even though they don't qualify under the lemon law strictly, the presence of the lemon law has encouraged them to try to negotiate on these items, to try to negotiate to satisfy the consumers. Pero there is a way we can tighten it up.
No, thank you, Mr. Tamayo, for bringing that to our attention. And maybe we can ask for your help to further improve the bill to capture some situations which are not literally covered by the provisions of the law, but should be, hindi ba? Out of a sense of fairness to the buyer. So we might be needing your help, sir, kasi because of your experience in this area.
Okay po.
Yeah, but thank you for that. Ngayon ang question, Mr. Tamayo, ito question lang just in case you know, no? Let us say, for example, how come the dealer did not just replace the vehicle? Wala ba siyang relationship with the manufacturer so that the manufacturer will also understand the situation of the dealer, that yung the vehicle that was returned to you, we will also replace it with a brand new one. Wala bang ganong arrangements between manufacturer and car dealer?
Sir, I'm not entirely qualified to answer that po. Because the relationships will change depending on whether your dealer is part of a official network. There are some distributorships that are run by the manufacturers themselves, some that are run through intermediaries, and then the distributor, you'll have dealers, sub-dealers or sub-groups run by dealership groups naman. So I think the representative from CAPI would be better able to answer that.
Yes.
Will vary, and the quality of service will vary also.
Okay. Thank you, sir. I just asked that in case you have an idea. So, Campi? Campi is here?
Yes. Good morning, Mr.
Mr.
Chair.
Gutierrez? Yes, sir.
Yeah. I'm Attorney Romel Gutierrez, President of CAMPI, or Chamber of Automotive Manufacturers of the Philippines, Inc. Yeah. Before we state our position, Mr. Chair, allow me to just give my comments on the earlier statements about, you were asking, Mr. Chair, about the number of repair attempts, no? The Lemon Law actually was patterned after laws, foreign laws, no, on related to lemon. So repair attempts are common to foreign jurisdiction. And we also noted several cases that are actually several customers invoking lemon law, which are not qualified. Thank you, DTI, for pointing that out. Yeah, and then we also confirm that there have been cases that manufacturers are actually are doing their best, no, to solve the problem. Allow me, Mr. Chair, if I may, to read our official statement. Yeah. The Honorable Chairman of the Committee on Trade, Commerce, and Entrepreneurship, Senator Aquilino Coco Pimentel, honorable members of the committee, ladies and gentlemen, good morning. The Chamber of Automotive Manufacturers, or CAMPI, of the Philippines, Inc., CAMPI would like to thank the committee for inviting and giving us the opportunity to participate in today's public hearing. CAMPI recognizes the objectives of the proposed Senate bills related to the existing lemon law. CAMPI would like to manifest before this committee its strong support to the existing lemon law as part of its social responsibility and commitment to the welfare and safety of motor vehicle owners as buyers and primary stakeholder. CAMPI will submit separately its position paper on this bill. Meanwhile, please allow us to share our initial comments for the consideration of the committee. The implementation of the existing lemon law has generally been effective. The law has strengthened consumer protection for motor vehicles The procedures outlined for availing of the Lemon Law rights clearly recognize the rights of the brand new motor vehicle owners, buyers, and the obligations of the manufacturers, distributors. With the proposal under the bills, there is a need to establish a coherent technical standard in determining the coverage of critical non-conformity issue. Related to this, evidence is imperative to prove or measure that critical non-conformity issue substantially impair the control or directional stability of the vehicle, including its overall safety. Limiting the number of repair attempts and or immediate replacement as first remedy may ease the Lemon Law's owners' right in the short term, but it will not achieve reforming the overall automotive warranty structure in the long run, which may be detrimental to the automotive industry. This also includes other direct and indirect industries covering parts and components providers, suppliers, and after-sales service. The nature of the automotive supply chain, including the availability of parts, components, or assemblies, is complex and sensitive to various external economic, environmental, some governmental regulations, logistics, other factors. Improving the automotive supply chain interconnectivity requires extensive network of supporting industries, including parts makers and other related services, which unfortunately remains a challenge to the automotive industry. Specifically for used car Lemon Bill, statutory parameters and mechanisms must align with manufacturers' written warranty coverage, including duration, options for repair, repair of defect, among others. Finally, CAMPI would like to take this opportunity to manifest its interest to participate in future discussions and or meetings on these important measures. Thank you very much for your kind attention. Thank you, Mr. Chair.
Thank you, Mr. Attorney Gutierrez. You're submitting your position paper on the two bills, pati na yung used car Lemon Bill.
We will do that, Mr. Chair. Although offhand, Mr. Chair, Senate Bill 659 talks about used car dealers. No, CAMPI members are distributors of brand new motor vehicles. So we will, but we have concern here, if I may, Mr. Chair, only on the specifically on the warranties. No, baka we may have conflicting. Especially on the periods covered, no, for used car and brand new, because the warranty actually would reach up to 3 years, no, yung warranty natin. So anything, let's just review, Mr. Chair, yung sa used car, baka it may happen within the 3-year period, then we'll reconcile as much as possible yung warranty ng original ng manufacturers, no, versus the proposal under this Senate bill. Thank you, Mr. Chair.
Thank you for pointing that out. So, Attorney Gutierrez, I'm sure alam mo ito. How come 4 attempts? Even sa other jurisdictions, sabi mo, how come 4 ang na-fix na attempts?
Yeah, because the nature of the non-conformity actually, as defined in the law, really pertains to the safety and comfort, and also we want to make sure that we are given the opportunity to repair it not just once, but 3 or 4 times, Mr. Chair. So yeah, that's really the practice, Mr. Chair.
Okay, kasi kung parang kung strike out rule nga dapat 3 lang pero naging 4 pa rin. So I'm just wondering bakit naging 4. Sige. So LTO ASEC Galvante is here.
Good morning, Mr. Chair. Morning.
Any comments, sir? Just in case meron, just in case. Yes, sir.
Yes, Mr. Chair, very general, Mr. Chair, and very short. Considering the bill has the same intent of providing after-sales security and protection to buyers of motor vehicles, the LTO interposes no objection, Mr. Chair. Particularly, this will ensure the motor vehicle sold regardless if the unit is used or brand new are roadworthy, thereby promoting road safety, which is primary objective of this office. That is our short comment, Mr. Chair. Thank you and good morning.
Ang question ko nga kay Attorney, balik ako sa Kampi, sir, at Attorney Gutierrez.
Yes, Mr. Chair.
If there is a non-conformity issue or a safety issue, or basically, di ba, yung parang non-compliance with the specifications expected by the buyer of a brand new vehicle,
Yes, Mr. Chair. Yeah.
why not just satisfy the consumer and replace it? I mean, don't you have a relationship with the manufacturer na naintindihan naman ni manufacturer that I also have to satisfy the ultimate buyer of my product, and then I can now replace the vehicle, return to my dealer with another vehicle. Kaya ko gawin yun eh. And then yung defective, yung alleged to be defective vehicle, the manufacturer will just fix it or improve it and find a way to dispose of it. Balik sa kanya yung problem. Bakit hindi po ganun ang attitude natin?
Apo, okay. Tama yung tanong nyo, Mr. Chair. But again, the manufacturers, no, which are actually foreign principals namin, meron silang warranty, no, and we recognize the remedy under the law, no, eventual replacement, no? But in the meantime, yun lang ang consideration natin. Let's check first, no, yung conformity with the warranty, because precisely we issue the warranty and give us the opportunity to repair, no. So wala naman question as to the replacement later on. We respect the law, we respect the penalty under the law, but again, yeah, we have to follow certain procedures. And as I mentioned earlier, the procedures under the Lemon Law gives us the opportunity, no, especially in the repair attempt. And with due respect, Mr. Chair, hindi naman pwede siguro one time lang replace natin kaagad. It's also a huge investment on the part of our yung mga distributors locally, no. And again, we follow international standards naman. So hindi lang basta-basta ganon, Mr. Chair. Thank you.
Okay. I got information that California Lemon Law, 2 repair attempts. Attorney Gonzalez, what can you say? Gutierrez, Attorney Gutierrez. Yes. 2 repair attempts.
Yeah, well, of course, we have naman. At least hindi isa, Mr. Chair. So during during our deliberation at that time, yeah, we agreed that 4 repair attempts are actually reasonable because by the very nature of the defects, no. So and you know, hindi naman sa the presumption is we distribute naman quality vehicles. That's why we really want to make it sure that kung meron man non-conformity dyan would really pass the scrutiny of hindi lang kasi ang inspection dyan, Mr. Chair, hindi dito lang sa local distributor, but we also involve yung foreign principals natin, yung mga technicians natin, no. So that's why yung una dito lang muna, in fact sa dealers lang muna yan, and then after number of attempts, the distributor, no, would come in, and then kung talagang we involve yung ating foreign principals, no, yung technical people nila to look into the defects which are not in conformity with the express warranty of the manufacturers, Mr. Chair.
Ito lang kasi yung thinking ko, sir, at Attorney Gutierrez, no. I'm sure over time nag-improve na rin yung manufacturing processes ng car manufacturers, eh. And they should be more confident now, no, that their output, the final output, would be freer of defects, or would more be more compliant with this specification. So, if we lessen the number of repair attempts, dapat nga actually ang feeling ng manufacturers, less na yung number of lemon vehicles that we are producing because of the improvements in the processes, improvements in the checking, quality inspection. Ano po masasabi niyo, Sir Attorney Gutierrez?
Yeah, thank you, Mr. Chair. In fact, our sales, last before the pandemic, was already reaching 400,000 units per year, and with 39 cases of lemon law and vehicles complaints, it's still very small, Mr. Chair, and we understand your thinking on this, that dapat naman talaga perfect na ito. But again, we have to look into each case, how and what causes the non-conformity to the warranty. Mr. Chair.
Sige sir, I get your point, but siguro yung repair attempts medyo maging ano tayo ron, maging flexible tayo ron.
We can discuss that, Mr. Chair, during the technical working group if you would.
Mr. Tamayo, Mr. Tamayo, raising your hand, sir. Yes, go ahead.
Yes po. I'd like to agree lang with Attorney Gutierrez that yung California the two repair attempt rule for California is a bit strict. It's ideal actually, pero medyo ideal lahat ng laws sa California, and it might not be something applicable to us yet, but if we're going to go for that, we should consider as to which parts of the vehicle that it would apply to, because there are some certain non-conformities that we could allow them more repair attempts, and then there are certain really critical ones that you could go down to 2, pero it has to be studied further. It might be too ideal for our case. Plus yung sa buyback of the customers, from our side, what we've seen of talking to customers who have had these lemon problems, I think the dealers and distributors, after enough time has passed, they have expressed the willingness to buy back or to refund the customers. Yung usual hang-up lang talaga po is the amount to be refunded. It's whether it should be based on the cost of the vehicle at the start, a brand new cost, depreciated cost, for the depreciated at the time of the first non-conformity, depreciated at the time of the last non-conformity. So there is a willingness to buy back, sir. The problem lang talaga is it's just a haggle for what value to use. Sometimes the customer will have the right to demand a higher value. Sometimes we've seen some customers demanding more than they're entitled to. So it's not the unwillingness naman on the part of the dealers or distributors. It's just finding the right price between the two parties, the price that is agreeable to both.
Mr. Tamayo, how many lemon law complaints have you received as an editor of your publication?
Well, I'm trying to recall, but because some of those complaints reach the EIC, not all of them reach the editorial staff, but people do reach out to me in my personal capacity, knowing me in real life or knowing of my work. Siguro I've talked to maybe a dozen, maybe 12 to 20 owners. Some of them have been satisfied after 2 or 3 weeks. Okay na, they won't contact us again because they've reached a deal with the dealer. There are some that personal friends, they say, this could be lemon law, but the dealers treated me right, so I don't care anymore. The one I was saying that had 4 repairs within 2 years, since the dealer treated him right, didn't charge him anything, he said, I don't care about it anymore. I'm selling off the car and I'm done. There are a few that are still in arbitration. 1 or 2 that I've just talked to before this. One who's asking me right now, ano yung fallback ko? Because he heard na we were talking and he said, dyan ka pala sa Senate hearing, what's my fallback here? I said, looking at the current law, hindi ka naman covered, pero when it passes, maybe you'll get more rights. But this one is already for buyback na ng dealer. Like I said, the only question is what valuation is fair to both parties. So understanding on the part of the dealer and distributor, there's already a sunk cost, and once the vehicle has been used for a certain amount of time, there's a depreciation that should be applied. But in deference to the consumer, they expected it to be fully problem free for at least the first year. So they do have some rights. So it's not for me to say since I'm not a lawyer. I can't say what is fair for both, but it's something that should be baked into the next law, I guess.
Okay, just for my education, since real life example yung kinikwento mo, what is that complaint na linapit sa iyo na you said na hindi siya covered ng existing lemon law, so that I will know the nature of the complaint?
Yung complaint kasi is covered generally under the lemon law. Basically, my 4 visits, and then the dealer has agreed na buyback na lang. But the buyback price is depreciated price. They're asking, since maaga nag-start yung first problem, as in driving away from the dealership, napansin niya na may konting ingay sa suspension. This was one of the problems. And then, sabi ko, yeah, that is a safety issue. Under your proposed revision, any problem within the first 1,000 kilometers would be a full refund. Pero under the current law, walang ganyan. They're given a chance to fix it. Now, they haven't fixed it. So at the end of it all, they're offering him depreciated price. Pero ang gusto niya, since sobrang aga lumabas yung first problem, gusto niya full refund. So this is why I was looking at the proposed amendments. I was thinking that's a good amendment because it covers cases like this.
Okay, so thank you for that. At least that's a real life, although there is a willingness to satisfy the consumer buyer, may real life issue pa rin because what is the amount, depreciated amount or the purchase price. Okay, so thank you for pointing that out. So any other comments? Let's just open up the discussion also on the Revilla bill on used vehicle lemon law. Yes. Kasama na Attorney Dimagiba. You can discuss that too. The Used Car Lemon Act, Senate Bill 659, and the Act amending the Philippine Lemon Law, Senate Bill 2046. Yes, sir. Go ahead. Attorney Dimagiba.
Thank you, sir. Actually, I submitted a very short position paper, and I called your bill very Solomonic about the one repair attempt. I think very pro-consumer. And in the light of other program also of government on vehicle safety, particularly the motor vehicle inspection system, I think it's about time that we can tighten requirements of our lemon law by reducing the repair attempt from 4 to 1, Senator Pimentel had proposed, and for a short period of time of 1 year. You must recall, Mr. Chairman, that most vehicles in the market now, particularly SUVs, are imported vehicles. They're not manufactured. These are completely built unit, and they're not manufactured or assembled in the Philippines, except for 2 or 3 models that are part of the local car manufacturing program. So I guess when I say we, I was in DTI 5 years ago when the lemon law was being discussed also just today. And we thought at the time that for repair attempt was the industry practice, as in fact most countries in the US, most states in the US and some in Europe had lemon law that provide for repair attempts for the same defect. But with the improvement in government program on ensuring safety of vehicle, also with the government program to encourage and protect local car manufacturing industry, I think filing of your bill is timely. in relation also with this parallel policy development in the matter of safety of vehicle. So definitely, use the word Solomonic, talagang Solomonic. I mean, even California pala, 2 repair attempt. We could be the model for the 1 repair attempt lemon law. I'm not sure in Singapore whether how many repair attempts for vehicle under their lemon law. Having said that, in the case of the bill of Senator Revilla, our proposal is to limit the used car lemon law for the business to consumer relationship, meaning a trader and dealer selling to consumer for the limited period proposed in the bill. Pero yung consumer to consumer, in other words, I just decide to sell my second-hand car. I don't think it, siguro yung traditional civil law principle of I'm selling it to you as is where is should continue to be the contractual relationship between consumer to consumer. But between a trader and a dealer to a consumer selling a used car, I think another Solomonic bill filed for that purpose. In the Philippines, I believe this also opened other opportunities for lemon law, not only for vehicle, the chairman. I think in one of the meetings on the lemon law, I shared information that in Singapore, lemon law is also extended not only to vehicles, but to other goods and commodities. So with that, I think the bills are straightforward. This should be ready for the recommendation, favorable recommendation of the committee. Thank you very much.
Attorney Dimagiba, what other items was the concept of a lemon law extended to? Gusto ko malaman para malay mo magawa natin dito.
Mostly appliances and video equipment, Mr. Chairman.
Yung mga parang so-called the big purchases, no? Kasi
hindi yung mga non-consumable, hindi yung mga consumable items.
Hindi yung mga consumable pero mga big ticket purchases na from the point of view of the average consumer. That's the reason why I came up with this bill. Kasi sabi ko it's the purchase of a motor vehicle here in the Philippines is like a purchase of a home, of a house. It's from the point of view of the consumer, it's a very big financial decision. That's why sana we take
it's still very expensive now.
Yes, very expensive. Kaya nga we have to take
with this safeguard duty imported vehicle. I guess your bill really was given more teeth. Given more teeth because you have to pay 100,000 plus 12% VAT for an imported vehicle and 70,000 plus 12% VAT for the locally manufactured vehicles. I guess consumers deserve a better remedy by reducing the lemon law period to your bill could not only be Solomonic but precedent setting, just 1 repair attempt for a limited period, 1 year, for non-conformity. But I think, Mr. Chairman, you should also push. I saw a LTO representative just where the vehicle inspection system stands now. Because even during our time, that issue played a major debate, because it helps. It helps consumer determine how good and how bad his car, a brand new car for that matter.
Tama po yun. Kasi although, let us say there are relatively few number of complaints based on the lemon law, but from the point of view of that person complaining, that's the world to him or her kasi ano yan, pinag-isipan niya siguro ng kalahating taon, isang taon yung pagbili ng vehicle. Eh. It's a very big decision for him and then na-disappoint po yung consumer. I think I saw Attorney Gutierrez no raising his hand. Yes, sir, Attorney Gutierrez.
Yeah, thank you, Mr. Chair. Yeah, of course, we respect the opinion of my good friend, Attorney Dimagiba. We used to work together on this lemon law. Yeah, but let me comment, Mr. Chair, on what he said, and I'd like to refer to the statement earlier of Mr. Tamayo. I say, as correctly pointed out by Mr. Tamayo, I think the repair attempt should be depending on the nature of the non-conformity of the vehicle, no? And looking at the Senate Bill 2064, relating the repair attempt here with the amendment on Section 3, defining the critical non-conformity, if I also may, Mr. Chair, the critical conformity refers here to the issue which could affect the control or directional stability of the vehicle or cause injury to the people inside or outside the vehicle. If I don't know, Mr. Chair, what is the intention here, but my impression here is that this refers to a specific defect, which is the SUA, sudden unintended acceleration, no? And the repair attempt here is tied up with this kind of non-conformity. Okay, so we see the intention of the mandatory provisions here as something, an attempt, basing on the nature of the non-conformity. So again, I would agree to Mr. Tamayo, who said earlier that let's look at the kind of non-conformity and evaluate the repair attempts, the applicable repair attempts necessary under the circumstance. Yeah. That's my comment, Mr. Chair.
Chairman, can I add something? Can I add something?
Yes, go ahead, sir.
Yeah. I forgot to inform the committee that in the DOST now, Department of Science and Technology, I think they have a fully operational electromagnetic compatibility laboratory, which was not available 5 years ago when this lemon law was being debated in Congress. What is that laboratory is all about? It will help the chairman in it's sort of a CT scan for vehicle going to a laboratory. You put in the vehicle to a machine that will analyze through the use of computer. That's what are the non-conformity issues, particularly in electrical issues of the vehicle. So those kind of programs and activities of government, Mr. Chairman, had really, I guess, added justification for the review of the lemon law period. Kasi 5-6 years ago, wala namang mga ganun eh. We rely on the service facilities of the car company, the dealer, service shops. But now, with motor vehicle system and then with the electromagnetic compatibility laboratory of the Department of Science College, a very extensive laboratory. When I retired in 2016, they were only 50% completed, but I read about 2 years ago that they are fully operational. Those things added tools to determine non-conformity of a particular vehicle. So those are the kind of support. I think there are support technical facilities available now for a lowering of the lemon law period. That's the point I want to deliver. Thank you. Thank you.
Thank you, sir. And then, okay, but at least I see that you see the point in differentiating between a critical non-conformity issue and a non-critical or a regular non-conformity issue. So we can probably pursue that line of thinking na we can, anong tawag dun, bifurcate. We can divide into two the non-conformity issues. Okay, so but a question to Campi, Attorney Gutierrez.
Yes, Mr. Chair.
Is SUA a real phenomenon? Is it really an existing non-conformity issue of some vehicles?
Mr. Chair, sorry, Mitsubishi, if I may mention the brand, is a member of CAMPI, and unfortunately, this kind of issue is quite sensitive to the manufacturers, no? So we have not discussed or really resolved those questions at the level of CAMPI, no? So I would suggest, Mr. Chair, if I may, it's really we could probably ask, if we talk about the SUA, on alleged cases before, then I think Mitsubishi is in a better position to answer that. But as it is right now, Mr. Chair, the discussion, we have not resolved that so far within CAMPI, Mr. Chair.
Hindi, no mention of brand sana, or SUA lang, SUA as a concept. So if there is really SUA, that is a critical non-conformity issue. Agree ka, Sir Don? Critical yun, di ba? Critical. And then non-conformity, because hindi naman ako bumili ng vehicle para mag-accelerate siya na hindi ko siya nakokontrol eh.
Yes, correct, Mr. Chair. But again, it's critical, but we have to investigate just the same, no? Because again, there are warranties issued, and we just have to look at each particular case what really happened, no? We cannot at this point, Mr. Chair, exactly determine that was really a product defect.
Thank you for that. Unless LTO has a comment, Asek Galvante, on these mga SUA. Just in case lang meron, sir.
Mr. Chairman, I'm sorry, we do not have the expertise to make that kind of evaluation, Mr. Chairman, but we'll gladly participate in case our services are needed. But may I just state that at the moment, we don't have that kind of expertise, Mr. Chairman. Thank you.
Thank you, sir. Mr. Tamayo, yes, sir.
Yes. Basically, we've been following these cases very closely since they first came out, and we'll acknowledge that there is the possibility naman of runaway engine conditions or engine throttle malfunctions. The possibility is there. But in a lot of these cases, from video evidence that has been given or available on public domain, there are a lot of cases that have been resolved or been shown to be at least partially driver error. So a lot of the videos in public domain where you can see the rear of the vehicles involved in these SUA cases, you can see that there is no application of the brake pedal during the sudden unintended acceleration phase. Usually the application of the brake pedal comes at the end of that phase, as explained by our former technical editor, explained by our former technical editor, Mr. Furman Lau. The way you see it is the vehicle accelerates, there's no application of brake lights, and when it hits a wall or another vehicle, you see a sudden burst of smoke from the back of the vehicle. That happens because when you hit an object, the rear tires lift off the ground, so they're spinning up, and the engine is in over-rev condition, and it smokes. But it's not because the engine is running away. It's because typically the person there has their foot flat on the pedal, flat on the gas pedal, and then after 2 or 3 seconds of that, you see the brake lights come on and the smoke disappear. They've corrected it. But that's for those with video evidence given of the rear of the vehicle. So There are cases where the situation may be different. SUA can occur because of mat entrapment, where aftermarket mats installed either by the dealer or the customer or by a third-party supplier will cause the pedal to become stuck in the down position. It can be caused by electronic interference. Yung sinabi ni Attorney Di Magiba, yung bagong facility ng DOST that will actually help very much in identifying if electronic interference is occurring, or it can possibly happen because of wiring issues with the vehicles. Sometimes when aftermarket alarms or horns or radios are installed, whether by the customer, by a dealer, or by a third party, sometimes if you tap the wrong wires, this can lead to issues with the engine control. But this is where we have to be tread very carefully in analyzing the EM interference to show who has the liability there. Is the liability with the distributor, the manufacturer, the customer, or a third party? Because sometimes we have seen that vehicles even catch fire on the road. Aside from SUA, you have electrical issues of vehicles catching fire, only to find out later on that there is a modification to the vehicle that was not part of how the vehicle is manufactured. So I think the DOST facility will be of great help in trying to unravel the mystery of SUA and in actually strengthening the lemon law, allowing us to find out really what is going on underneath the hood.
Okay, thank you for that. Based on experience po yun, ano, Mr. Tamayo, from your investigation.
Yes,
Anyway, this is not a hearing about SUA na ano lang, parang side issue po yan, being if the vehicle suffers from SUA and that has not been modified, di ba? I mean that may qualify as a non-conformity issue. Anyway, any other comments on this? Otherwise, if there are no more comments, we will now, there will be two bills now, but separately, we will now conduct technical working group sessions separately on the two bills. Okay, so what am I referring to? Senate Bill number 659 of Senator Revilla and Senate Bill number 2046, an act amending the Philippine Lemon Law filed by this representation. Okay na po yun?
We're okay, Mr. Chair.
Campi and Mr. Tamayo, you're welcome to help us with some of the technical issues.
Thank you, Mr. Chair. Thank you for inviting us. We will be more than willing to join the technical working group.
Yes, sir. On the technical issues, on the policy issues, allow us to decide on the policy issues.
Yes, Mr. Chair.
Okay, so we can now move on. Who else did we invite for this ba? Wala na ba? Okay na ba? Thank you for those who participated in the Lemon Law bills. Okay, let's go to the Senate Bill number 1798. And for those who are finished with their business to the committee, thank you. Thank you from the chair. You are now permitted to leave us and take your lunch.
Thank you, Mr. Chair. Thank you.
Lunch. Okay, sir. Let's move on to Senate Bill number 1798, the Heavy Equipment Registration Act by Senator Revilla. Attorney J. Kerubin, please give us the gist of the bill.
Yes, sir. The compulsory registration of heavy equipment could curb, if not totally eliminate, the practice of unscrupulous contractors who leave projects unfinished, and also prevent the practice of leasing the same equipment to two or more different contractors who simultaneously work on different projects. It will prevent any, if not all, misrepresentation of contractors with regards to ownership of heavy equipment, thereby helping the Government Bids and Awards Committee. in the determination and compliance of pre-qualification requirements for them.
Thank you for that. So I could see around the 3 representatives from ASEL, Association of Carriers and Equipment Lessors. No? Can you tell me, kahit sino po sa inyo, how is it done now? Is there a registration system for heavy equipment right now? ASEL, and then you can continue with your position on the bill. Yes, ASEL, who wants to speak? Your president, Mr. Angeles. Yes, sir.
Unmute mo, Dio, unmute.
We are thankful to the Honorable Senator Coco for giving our association the opportunity to provide our position on the draft of Senate Bill 1798. Currently, Senator, wala pong registration yung mga equipment natin. Unfortunately, the members of our association have serious reservations on the compulsory registration of heavy equipment and the types of registration: initial, renewal, transfer, and lease. We believe that such registration would be an additional financial burden to our members who have already been adversely affected by the current COVID-19 pandemic and various quarantine measures. More importantly, we believe that the objective of curbing or prohibiting malpractice on unscrupulous contractors can be better addressed by a specific legislation punishing or penalizing such acts instead of imposing the compulsory registration of heavy equipment. Lastly, we foresee difficulty in the implementation of registration due to the location of heavy equipment in remote, mountainous, or far-flung areas. Consequently, we believe that there is a need for a deeper study on the bill itself. Thank you again, Senator, for listening to the and to the pleas of our members. Thank you.
LTO, can you guide this committee? What would be the possible benefits if we have a system to register heavy equipment? Kasi ngayon daw wala. Do you confirm it, sir, na wala ngayon?
Yes po, wala po.
Wala po, unless the vehicle are also being used nag-transfer sa ating mga public roads. But generally, wala po, Mr. Chairman.
Because these are too heavy naman, ano? At saka, but what if it temporarily has to use our roads? May special permit siyang kukunin o hindi na?
Yes, Mr. Chairman. Siguro kung magtra-transverse lang po temporarily from going from one side to the other, yun lang po siguro, Mr. Chairman. But again, as a general rule, kung hindi po ginagamit yan sa ating pampublikang lansangan, hindi po kailangan ng registration.
Doesn't registration serve another purpose, ASEC Galvante? Wala ka bang maisip na ibang purpose ng registration except that, because it uses our public roads, mag-contribute siya to the maintenance and upkeep of our public roads?
Again, Mr. Chairman, siguro kung madalas na maaari po. But meron po akong nabasa yun ng mga panukala noong 2007 kung saan by way of monitoring also yung compliance sa mga contractors on their project. Isang note po ito na isang senador na nag-propose na dapat they should also be registered kasi meron pong mga tendency daw na abandon yung project, hindi tinatapos. Probably by recording them or registering them, alam ko sinong hahabulin, Mr. Chairman. Comment ko lang po yun, Mr. Chairman.
Tama. Mukhang that's one of the purposes of the law. So any other comments? Basta ASEL, you're against it for additional expenditure. Wala ba kayong nakikitang benefit na ma-register yung mga heavy equipment ninyo?
Mr. Chairman, we'll conduct further evaluation, registration, and study. At again, dahil gumagamit po ng kalsada yan, lalong-lalo na heavy equipment, kailangan din po makakontribute sila sa maintenance. So probably they should also be levied some amount, Mr. Chairman.
Okay, that's the point of view of the LTO. Pero Comsec, can you call SIAP? Kasi SIAP is the registration office pala eh. We need their inputs then. But sige, back to ASEL kasi ang opposition ninyo additional expenditure. So wala kayong nakikitang benefit if heavy equipment has a registry system?
Senator Coco, actually nakita naming advantage nitong registration is yung kumbaga pwede naming yun sa it can help yung recognized proof of ownership which magkakaroon ng bankability yung equipment. Saka this may also means lower leverage yun sa premium ng insurance. Actually yun yung nakita naming advantage. Pero medyo na mas malaki yung disadvantage yun yung expense sa aming mga members.
Mr. Chair, can I recognize?
Mr. Dicena?
Yes, thank you, Mr. Chair. On the position of PCA, we know the fact that construction industry is one of the biggest contributor in our domestic economy. No? For us, the mandatory registration will turn these pieces of heavy equipment as an asset, giving them a better chances of being accepted as security or as a financial loans or obligations applied by the contractors. No? Having been registered, we can see the ownership of heavy equipment can easily be determined, right? And of course, the creation of the registry will make the heavy equipment data available nationwide. This will assist contractors working in different localities in terms of finding or leasing heavy equipment. And if the mandatory registration will complement the 30-year infrastructure master development plan if approved. However, we recommend the following: that rather than being a source of revenue for the government, it should be looked as one of the way to further strengthen the industry. Rather than as a kumbaga pagkakakitaan ng ating government. And then the registration may be in 3 to 5 years, subject to inspection to ensure safety, like the sale, transport, inoperability, and the like, and equipment not registered. No? And then also, there should be also the requirements for foreign companies applying for new or renewing contractor's license, so that at least we have an equal regulations for local and foreign contractors. That's it, Mr. Chair.
Okay,
Mr. Chair, can I...
Pagdating po, Mr. Dicena, sa equality, I think we can easily apply this kasi basta heavy equipment registration system. Siguro ASEL, this group, you can participate in the technical working group. Just look at section 10. Kasi if cost ng ating problema, tingnan natin yung section 10 kasi wala namang amounts doon, but we can clarify the language that to accommodate the idea of Mr. Dicena that this is not for revenue. Diba? The fees must just be sufficient enough for the registration process to maintain the registration na meron namang benepisyo. So, yun siguro ang proper balance na habulin natin na hindi siya financial burden kasi hindi siya for revenue, hindi siya for maintenance of the roads that you are not even expected to use anyway, but just for to maintain the registration process. Mr. Spirito?
Yes, Mr. Chair, thank you very much. Actually, we are cognizant of the comments of ASEL that they are apprehensive, no? And that it will add another bureaucratic process for construction companies, as well as burdensome fees and taxation, no? On top of existing taxes and duties. But we are hopeful that rather than seeing this bill as a source of revenue for the government, it will instead be implemented as a measure to streamline processes that will strengthen the construction industry. And also, under the SIAP, the Philippine Domestic Construction Board can establish a way of registration by which we can complement the efforts of the PCAB, no, the Philippine Contractors Accreditation Board, in evaluating the applications of contractors for new and or renewal of licenses. Kasi dito sa renewal ng licenses nila, nandito yung list of equipments that they are using for their specific projects. Yun lang, Mr. Chair. Thank you.
Thank you. Ms. Gacho, Ma'am Gacho, you're raising your hand up.
Yes, thank you, Mr. Chair. As mentioned by our chairman, Sir Levi Espiritu, we are cognizant of the position of ASEL and PCA2 as we have consulted them prior to the submission of our position paper. The PDCB po is ready to work with the Senate on the creation of the technical working group to determine yung IRR. Thank you, sir.
Thank you, ma'am. Asek Prudente. Andiyan pa ba andiyan po si SIAP?
Good afternoon, Your Honor.
I think SIAP,
Mr. Chairman.
SIAP will be the main implementer of this law of this bill if it becomes law. Any comment from SIAP?
Good afternoon, Mr. Chairman, Your Honor. We are now in the process of consolidating our position for this particular bill. As of today, our Philippine Domestic Construction Board has submitted its position paper to the SIAP Secretariat, and we are now soliciting other comments and recommendations from our other boards. So we will schedule this particular bill in our coming SIAP board meeting this Mayor, Mr. Chairman, and rest assured of SIAP's full support in the passage of this bill.
When is the meeting, sir?
Our next SIAP board meeting will be this coming May, sir. Matagal pa, pero sir, we are consolidating the different recommendations of our other boards like PCAB, our domestic construction, and also SIAP, sir.
Ang main concern ko lang is if this bill will benefit the industry, will improve current systems, and also prevent the evil that it wants to prevent. Yung nandun naman sa explanatory note ni Senator Revilla. So and then just avoid making this another financial burden. Yun lang, kung magawa natin lahat yun, I think we can safely endorse this bill for plenary approval. What do you think? So Asek Prudente, and anyway, give us a position paper na lang, sir, even before May. Kahit yung ARA, what is the SIAP DTI thinking?
Yes, we will submit, Mr. Chairman. This will allow the industry to have a data bank for heavy equipment in all parts of the country, and will be used as a platform for partnership and business opportunities, sir. So such data will complement our 30-year infrastructure master plan also to know the capacity of our local contractors in the areas where we need to build up for the rest of the country.
This is a statement of Senator Revilla in his explanatory note. The compulsory registration of heavy equipment could curb, if not totally eliminate, the practice of unscrupulous contractors who leave projects unfinished or after merely obtaining the initial mobilization fee for a particular infrastructure project completely disappear. Nangyayari ba yan? Nangyayari pala yan? Any comments? Nangyayari yan sa real life?
Mr. Chair, can I comment? Nangyayari yan actually in real construction projects. So this bill, currently our position paper, the PDCP, supports this bill, no? And we are just looking at we're just reviewing the apprehension of the other stakeholders in the industry like ASEL in their apprehension on additional fees, which we understand. And we took that into consideration in our position paper. But basically, the mandatory registration will indeed help the construction industry. Yes, Mr. Chair.
Meron pa sir, ito pa sinabi pa ni Senator Revilla, this proposed measure would also prevent the practice of leasing the same heavy equipment to 2 or more different contractors who simultaneously work on different projects on the same dates but on different sites. Nangyayari pala yan? So,
yes, Mr. Chair.
Nangyayari yan, Mr. Chair. So we want to prevent that from happening. To have registered licensed contractors who are doing this, Mr. Chair.
So, ang dami palang questionable practices na pwedeng ma-address nitong bill na ito. So, suportahan na lang natin ito and then i-address natin yung concerns po ninyo. Yun lang, ang narinig ko naman ngayon is the additional financial burden. So, let's not make it an additional financial burden. Any other comments? Yes, sir. Yes, President of ASEL, yes. Sa Angeles. Unmute, sir. Unmute. Okay.
Senator Coco, we are willing to join the technical working group for this bill.
Yes, sir. We will invite you, and then you guard lang the financial burden. Wag nating gawin ganon. This is not meant to raise revenues. Gawin na lang natin ganon ang reason natin. Any other comments? Mr. Marquez, you want to say something? Mr. Marquez muna for Mr. Dicena.
Yes, okay na po ako. Likewise with the other stakeholders, we support the bill.
Okay, Mr. Dicena.
Thank you, Mr. Chair. We'll submit a position paper for this bill, Mr. Chair.
Okay, I could see. Thank you, sir, Mr. Dicena. I can see E.D. Barrera. You want to say something, sir? Just in case? Wala? Nothing? Okay, thank you. Asa Galvante, anything on this?
Mr. Chairman, yun pong nasabi ko kanina, and we're willing to participate in the technical working group for some concerns that may affect LTO, Mr. Chairman. Thank you.
Sige, okay. So I think let us achieve the objectives being sought by this bill. Kasi kung ganun yung mga objectives niya, kailangan natin tong batas na ito. Ang dami pala niyang sinasagot na problema na kinonfirm ninyo na nangyayari. Okay, so let's now call for a technical working group for this bill. Then we will invite the stakeholders, the government agencies also. So I'm referring to Senate Bill number 1798. An act providing for the compulsory registration of heavy equipment filed by Senator Revilla. Okay, so that's how we will dispose of the matter. So for those who attended our hearing for this particular subject matter, so you have permission now to leave us, and thank you for attending. Thank you very much. So
Thank you, Mr. Chairman.
thank you. The last item. The last subject matter in our agenda would be the amendments to the Warehouse Receipts Act. Sige. So I saved the best for last. Tama ba 'yon? Okay. I think this is the most complicated of all, no? Of all the subject matters. Andale. Who did we? Okay, so
Easy, sir.
Attorney J muna. Let me recognize my legislative staff, Attorney J. Kerubin, to tell us. Mention, since there's more than one measure, Attorney Kerubin mentioned. Please mention the Senate bill numbers and then the gist of the measures.
Yes, sir. Senate Bill 6328, Senate Bill 2049, and House Bill 8698. All seeks to amend the current warehouse receipts law and establish an online warehouse receipt registry containing relevant information on warehouse receipts, warehouse operators, and warehouses. Through such registry, the public, especially banks and other financial institutions, may easily verify the quantity and quality of goods covered by each warehouse receipt. As warehouse receipts become more reliable, farmers may now use their harvest as evidenced by warehouse receipts as collateral for secured loans.
Okay, so thank you for that. So this is a measure meant to help our farmers, give them access to financing or an instrument, a so-called financial instrument. Who have we invited? Can we siguro before recognizing government, let me recognize some of the proponents of the bill so they can tell us more about the benefits of having this as a law. Okay, so do I start with former Secretary Teves and then Attorney Abad siguro? Okay, so Secretary Teves, sir, you want to give us the salient features as well as the benefits of the bill?
Thank you, Mr. Chairman, and thank you, everybody. In the interest of time, Mr. Chairman, can I just read a portion of the statement of support which we submitted to Ms. Jingle Alam, and so that the rest can be taken up by the other resource persons. The portion that I'd like to say would be that the passage of the bill would be beneficial for the following reasons. One, a farmer would be able to deposit his goods and products in an accredited warehouse in an exchange for a receipt certifying the storage of goods of a particular quantity and quality. The farmer can then use this warehouse receipt as collateral for a bank loan to finance his next cropping season. This allows farmers to sell produce at the best times, attain a better income, and help decrease post-harvest losses. Two, it will address the bank's lack of confidence to lend to SMEs and farmers. The bill brings integrity in the use of warehouse receipts as collateral by providing for accreditation of warehouses engaged in the issuance of warehouse receipts. It also provides for the requirement of bonds and insurance for warehouse operators and a guarantee mechanism through the Philippine Guarantee Corporation. The centralized IT system or repository of all warehouse receipts issued complements the risk management tools of banks in doing their due diligence. Three, the centralized repository of warehouse receipts will also support the agricultural sector by allowing for data on crops to be comprehensively captured, which then provides the market information needed to make strategic policies and decisions concerning food security. Fourth, it will support the growth of e-commerce and warehousing by enabling supply chain finance, minimize logistics and fulfillment challenges brought by the growth of e-commerce, and bring more integrity and security to transactions. And fifth, finally, it will help advance the attainment of President Duterte's 10-point socioeconomic agenda, particularly Agenda number 5, which is to promote rural and value chain development toward increasing agricultural and rural enterprise productivity. We hope the distinguished members of the Senate act urgently on this measure to help attain more inclusive economic growth. Mr. Chairman, in addition to the statement of support, we have also updated our talking points or frequently asked questions on warehouse receipts. This might be helpful to the Senate staff or to the technical working group that you might form in relation to this bill. We're prepared to submit these updated talking points and or frequently asked questions, Mr. Chair. Thank you very much.
Thank you, Secretary Teves. Did we lose Attorney Abad? Okay. Attorney Abad is still here. Okay. Sige, Panyarog, go ahead.
Okay, Chair Coco, I'm here. Thank you very much, Mr. Chair, and your honors, good senators, for having us. I'm supporting, of course, all the statements put forth by my colleague, former Secretary Teves. But I wanted to add, as legal advisor to this effort, and the justification or rationale for having a new warehouse receipts law is to begin is really to update the 1912 legislation so that it becomes usable and user friendly also to all who need to use it. What we envision actually is not just to help the farmers. It will help the agricultural sector and rural areas greatly. But anything actually that is in a warehouse can be subject or can be part of can be evidenced by a warehouse receipt. So the warehouse receipt as a document of title and when negotiable is a means of trading the commodity or the product that's inside the warehouse without having to physically do the sale. In which case you can actually save your warehouse receipt until it's a better time to sell it or to negotiate it for value. Then there's an added dimension, Mr. Chair and your honors, that we want to be able to see an electronically empowered system wherein you can trade products that are inside warehouses all over the country. But to able to do that, you need a legal instrument, which is actually in the form of a security, which can be traded electronically. And so the idea is to have to update the 1912 law so that it provides for the business law part, provides for negotiability and rights and liabilities between parties using the warehouse receipts, and also a government regulation part wherein the SEC now provides for the vouchsafing and guaranteeing that the products evidenced by the warehouse receipt are actually there, and will mitigate or prevent the fraud, which became the problem of the old warehouse receipts law and where it lost its credibility. So we think that this will create a whole system wherein the warehouses all around the country, all public warehouses and even private warehouses can be linked electronically, and people can do their trading of the commodities inside the warehouse on screen and online. So this will also be in line with supporting all the efforts to help us during the pandemic and even in the post-pandemic period. Thank you very much, sir.
Attorney Abad, you mentioned about the fraud. So yung 1912 law, when the warehouse receipts law was being implemented, there were lots of instances of fraud.
I think the big problem was falsification of documents.
Forgery, mga ganyan.
Forgery.
Yeah, and that's why I'm following it up. Can we use do we intend to use or can we use the blockchain technology here to make sure to lessen the to lessen the instances of fraud or even prevent fraud?
Oh, certainly blockchain will be useful in this process, or any system that's similar to this, no? That can have a sort of guaranteeing backwards, no, of the receipts.
Kasi otherwise, if we make it digital and yet walang mga ano man tawag mo doon, what do you call that? Mga features like the blockchain technology. Meron din digital fraud, hindi ba? So baka we just facilitate the commission of fraud.
Oh, the receipts will not have any value or credibility if the user doesn't feel safe na that the goods are really there, and that it's really evidence of the title to those goods. So you really have to have a system in place.
So
we also see the SEC as
two levels pala of concern. That number one, the warehouse receipt is genuine, and then
Yes.
it's backed up by real goods.
Oh, if they say that there's so much metric tons of this product, it has to be guaranteed.
Tama. Because it could be a genuine warehouse receipt, and yet the warehouse operator, is not is an irresponsible operator, nawala rin yung goods. Tama, pwede yun, Posible.
Yes. That's why there's a heavy responsibility on the warehouse operator. Yung mga guarantees niya and warranties to the products inside.
And then the main implementer of this law would be the SEC.
Yes, because it's actually in the form of a security. So yung regulation, it's really more like a securities regulation.
So because I can see SEC Commissioner Francisco is still with us, so maybe we can ask SEC for its comments.
Yes, good noon, Mr. Chair and other senators. Actually, Mr. Chair, we prepared a PowerPoint presentation, but in the interest of time, depending on your preference, Mr. Chair, we can also just read our statement so that we have more time to discuss. Whichever you prefer, Mr. Chair.
So just give us the gist of your position and then submit to us even the PowerPoint para we can go over it when not rushed. Again, go ahead, Commissioner. Yes, sir.
Thank you. So, Mr. Chair, once again, despite the existing legal framework for warehouse receipts and despite its potential to facilitate transactions over commodities such as grains, lending based on warehouse receipts is not commonly observed in the Philippine financial system. So when the Personal Property Security Act became a law, it opened the door for the creation of security interests over movable properties, such as crops or farm products. Nevertheless, more would still be done in order to boost agricultural productivity and trade, and one of which is to enhance the credibility of warehouse receipts. Through the proposed Warehouse Receipts Act that seeks to establish an electronic warehouse receipts registry characterized by accuracy and transparency in stored goods, coupled with safeguards such as the possibility of a warehouse accreditation council in one of the bills, that would enforce the standards for storage as part of its duty to accredit warehouses and warehouse operators. We believe that the resulting improvement in the integrity of the warehouse receipts as evidence of title to the stored goods they represent will be more beneficial. This measure, when passed into law, could allow farmers to access finance using a kind of property that they commonly have, which is their produce, deposited in a warehouse and covered by a warehouse receipt. With a credible warehouse receipt system in place, banks and other financial institutions will perceive less risk in extending credit to farmers, as well as to MSMEs, using warehouse receipts as collateral. This financing opportunity could then be tapped by farmers to buttress their operations and increase their yield or improve the quality of their products. Further, a reliable warehouse receipt system could pave the way for the Philippines to have a commodities market involving key agricultural products when warehouse receipts are issued electronically and subsequently traded in exchanges. Lastly, through the creation of a central repository of information on goods and crops covered by warehouse receipts, critical data on food inventory can be collected and utilized by the government in making strategic policy decisions concerning food security of the country. In view of these potential benefits from a modernized warehouse receipt system, the Securities and Exchange Commission supports the passage of the proposed Warehouse Receipts Act and welcomes the mandate ordained upon the SEC for the purpose of accomplishing the objectives of the law. Thank you, Mr. Chairman.
Thank you, sir. In one bill or in two bills, the SEC is the implementer of the law. In one bill, it's interagency, DOF, SEC, DA, and DTI. So I think we have DOF here. Ma'am Santa Ines, you're here, ma'am. If you have something to share with us, ma'am, go ahead.
Good afternoon, sir. Good afternoon, everybody. Good afternoon, Chair. As of now, sir, we do not have the official position paper. We are yet to submit our official paper, but definitely the DOF is supportive of the bill. We actually advocate for the passage of the bill. And I am speaking in not only as DOF, not only from the DOF. I also speak as a farmer. Actually, sir, I hail from Nueva Ecija, and sa amin po, I would like to share to you our experience during the last the twin typhoons, the last three typhoons during before the pandemic, that 2020. Maybe, sir, kung perhaps should there been should this bill been already already in place, siguro po malaking tulong sa farmers pagdating po sa warehouse, sa stock of harvest. Kasi po last not only during the last typhoons, but even before, years way back, even before these last typhoons, every time po magkakaroon ng typhoon, disaster, floods, or anything that is climate change related, nagkakaroon po ng malaking problema ang mga farmers dahil wala pong paglalagyan na walang warehouse na po pwedeng paglagyan ng mga stocks, dahil ang mga farmers usually ay pag after the harvest ibebenta na po yan agad diretso sa mga middlemen. And secondly, kahit po yung mga may stocks po ng palay, kahit meron silang sa bahay na naka-stocks, pwedeng paglagyan. Ang problema naman po, sobrang mura ng presyo ng palay. And so yung those two only, to name only two. Pero yun po, kung meron tayo nitong warehouse, kung maipapasa natin to, masasagot, may encourage po, we will be able to encourage the private sector to set up warehouses. Pwede pong magkaroon ng mga warehouses. At the same, kasi po magkakaroon ng business ang mga warehouses. And then secondly, on the part of the farmers po, pwede po nating ilagak ang not only for the farmers but only for the MSMEs. Yung pong ilalagak natin sa warehouse na stocks, pwede nating pwede pong naka-stock lang doon yung harvest, and then by the time na medyo tumaas ang presyo, saka po pwedeng i-dispose ng farmers ang harvest. So magiging malaking tulong po ito sa mga farmers. Sa ngayon po talaga pong talagang ang mga farmers na naiiwanan sa utang, walang natitira sa kanila dahil either dahil wala silang mapag-istakan na ibebenta nila lahat, bukod dun sa unang nasira lahat yung nasira ang harvest nila. Kung may natira sa kanila, wala silang paglalagyan, so ibebenta nila agad sa middleman. At ang middleman po, usually nakaabang na po yan at nagpautang na kasi yan sa mga farmers. Ang ginamit ng farmers para sa inputs to farm ay nanggaling po sa mga middlemen. So by the time na magka-harvest, pupunta po ang lahat ng produce sa middleman. Unfortunately, kung ang mangyayari ay magkaroon ng disaster o magkaroon ng maiiwanan po ang utang sa farmers at lalaki ang utang nun. So yun po, kung magkakaroon yun po yung scenario, actual scenario sa ng mga farmers. And then on the ground, yes sir. And for the MSMEs, malaking tulong din po ito kasi yung stocks din nila, magkakaroon sila ng chance para mapalaki yung kanilang negosyo. Ang stocks nila magagamit nila na collateral for loan is once po na-establish natin ang registry, ang Unified Central Registry for warehouse receipts, magiging mas madali na po ang pagpapautang on the part of banks and lending institutions dahil may confidence na sila para magpautang sa mga maliliit. May check and balance po. Madali nilang i-check madali nilang makita kung talagang meron ba talagang existing stocks ang MSME. So yun po, it will also address the ease of doing business natin na pinatataas natin, especially during this pandemic na talaga pong bumagsak ang ating bumagsak lahat marami po ang nagsara sa mga MSMEs. There was a time po na almost 70% of MSMEs ay nagsara during the lockdowns, either according to ADB po yun na either permanently or tentatively. So yun po, and we would like finally sir, we would like to thank you for supporting the initiatives of the DOF, and also I would like to share with everybody na yun pong itong warehouse receipts bill po ay offshoot ng PPSA, and the PPSA, the Personal Property Security Act, which was passed in 2018, na pati okay na po ang IRR, and the registry I would like to share with you would have its soft launch on March 25. So starting March 25 po, pwede nyo i-check ang central registry ng PPSA. So it would be similar to that Unified Central Registry, the warehouse receipts. So yun po, maraming salamat po. Thank you. We would provide the official position paper of the DOF as soon as it's as soon as possible, the RDS po, sir. Thank you, sir.
Ma'am, we shall await the official DOF position paper, pero kindly work on it so that we can issue a committee report immediately. Yes, Commissioner.
Yes, Chair.
Thank you very much, sir. Thank you very much.
Yes, sir. Just as an additional comment, naalala ko lang when Ma'am Irene said it. But aside from DOF, Mr. Chair, the Financial Inclusion Steering Committee, which is headed by the Bangko Sentral Governor, has also issued already a letter of support and endorsement, Mr. Chair, for this bill. I believe it was submitted just earlier this month through Senate President Soto. So, but we can, if the committee does not have a copy yet, we can also forward an advance copy of the same, Mr. Chair.
Please, sir, please. Before we hear from the NFA and the PSMA, Attorney Abad, I have a question. Yung scenario ni Ma'am Santa Ines, yung bagyo, ang kanyang scenario eh. Let's say force majeure destroys the items or the commodities stored in the warehouse. Is that what happens now? What happens to who becomes ultimately liable, especially if the warehouse receipt has been used for a financial transaction? Is that in the bills?
There's provision, Mr. Chairman, for insurance, no? Also the possibility of the use of field guarantee, no? Because we also have to take into consideration the possibility of force majeure.
Yeah,
but
force majeure.
Having mentioned typhoons, actually, that's why it's also a good idea to have this to have a deployed public warehouse system all around the country, connected online, because then at least it's better than having it on the field. Kasi kung nasa field talagang sira na, no? But with inside the warehouses, they will have a better chance of surviving damage. And then you can also be part of the database of all the stocks that are safe and available around the country. If something happens, then maybe you can deploy from places that were not affected by the typhoon, if you have that system in place. Yan yung other possibility. But of course, the warehouse operator as a business also has to have the insurance, and has to be prepared, no, for these inevitable these accidents or problems.
Yeah, thank you for that, Attorney Abad. Okay, and then as mentioned by Ma'am Santa Ines, this will also spur the development of a warehousing industry. The warehouse owners or developers or operators would professionalize warehousing, hindi ba? Kasi dapat we build better warehouses because of this law, if this bill becomes law. Okay, so we can now hear probably from the Executive Director Barrera. PSMA. Yes, sir.
Thank you, Mr. Chair. Can you hear me, sir? Thank you. My name is Kokoy Barrera. I'm with the Philippine Sugar Millers Association. PSMA represents around 70 to 75% of all raw sugar produced in the country. We would like to raise our concern on two items of the proposed Senate bills 632 and 2049, including the House Bill 8968, specific only to the sugar industry. Perhaps it's known to everyone that since the development of the industry before the inception of this republic, we were already implementing a KIDAN system. The KIDAN system is more than just a document of title. It has developed into an important tool in the sugar industry. For one, the KIDAN system is used by SRA to monitor the supply of sugar in the country, at the same time regulate supply pursuant to EU 18. So the existence of the KIDAN already answers the intention of the bill amending the Warehouse Receipts Law to have an integrity of the system, at the same time an evidence of title of the product. And this system since it's unique to sugar, the SRA and the industry has developed a certain expertise, which, if I may say, if you're not in the industry, medyo mahirap po maintindihan. Second is that the Kidan system, or the Kidans or the sugar Kidans, is a tool for transshipment of sugar, for export, and for trade. So it goes beyond the simple document of title as envisioned by the amendments to the Warehouse Receipts Law. And also the Kidan is used by government to impose liens, such as the liens of SRA to manage its operations, and by the Bureau of Internal Revenue to collect taxes, like the 1% withholding tax on raw sugar, and the advanced VAT and the regular VAT on refined sugar. Alam na po ito ng mga planners ng sistemang ito at ang dokumentong ito. That's why we have reservations on only 2 items on the said bills. One is on making SEC or an interagency committee as the regulator of the Kidan. And second is on the provision on electronization or digitalization of the Kidan. If the objective of electronization is to have a central registry, SRA is already functioning for that purpose. If any trader or anyone in the industry, or even banks for that matter, want to verify the authenticity of any Kidan, they just have to pick up the phone and call SRA regulation. In a matter of minutes, they can verify, even without SRA looking at the Kidan. SRA can verify whether the Kidan is fake or not. And to prove that this system is working seamlessly over the years, hindi naman po sa nagmamayabang, pero for the past 6 years, or even for the past 10 years, not one complaint for fraud, or for fake Kidans rather, or sugarless Kidan has been filed in court or with SRA. Not one. I can only recall one instance for the past 10 years when fake Kidans was brought before SRA. Ang nangyari po, they bought the Kidans without calling SRA for verification. Yun lang po, one instance for the past 10 years. So it shows that the system is working, and over the years, the system has been working very well for the industry. In addition to that, there is this concept na you just, for the warehouse receipts in general, that you just bring the product to the warehouse and have it stored. Sa sugar industry po, it's not that simple, because every week the sugar mill as operator issues at least 100 or even 1,000 Kidans to farmers who have delivered their canes to the mill. So imagine nyo po if that would be under a different entity which is not familiar with farmer mentality, with the system of the sugar industry. At the same time, you do electronization to that, to farmers who don't have internet connection. Our fear is that will lead to confusion and disarray in an already working system in the sugar industry. That's all, Mr. Chair. We will provide a more detailed explanation of our position, and also a recommendation on perhaps how to address our position in the existing bills. And lastly, may I request also that the various farmers federations and associations in the country be consulted, because to tell you frankly, we were caught unaware of this bill. Hindi po kami na-invite sa House, and in the Senate, in this hearing, we asked to be invited when we found out that this bill is subject for discussion. Yun lang po, Mr. Chairman. Thank you for having us. Magandang hapon po.
Thank you for asking to be invited. Maganda yung mga points mo. Hindi obvious sa akin, ha? Kasi sabi mo, you really have to get to know the sugar industry to understand. But Kidan is actually just another term for warehouse receipt, hindi po ba?
Correct, Mr. Chair. Correct. Yes,
So,
sir. That's why we're here, because
But you have your own culture. You have your own culture in the sugar industry. Is that your point? And
Correct,
then
Mr. Chair.
and then your point is maybe the other sectors of agribusiness or agriculture, they may also have their own culture in using warehouse receipts. Kaya you want the other farmers associations to be invited.
Chair.
Good,
Mr.
very
Chair,
good, very good point. I appreciate your suggestion, and then that's why I will ask our committee secretary, how come we never thought of inviting the other farmers association and even the sugar mill association asked to be invited? So siguro, Attorney Abad, is it a good idea to hear the farmers associations who are the ones depositing their commodities to warehouses?
Oh, yeah, definitely. You
Oo
have to
nga.
hear all the
Yeah.
voices. Oh. But we had, just to also clarify that in previous congresses, I attended the technical working group, and there was always a representative from SRA, or I remember the sugar industry, and maybe those who were involved with those previous TWGs can probably come up with the list, no? So, but certainly we'll take into consideration any inputs on how to legally reconcile this bill with the existing KEDAN system.
I think SRA was present earlier. Comsec, can you contact the SRA? But the SRA is the government agency. Ito namang PSMA is the private sector, 'di ba? Mr. Barrera, tama?
Yes, Mr. Chair. We are an association of sugar mills.
Yes. So yun na nga. So we have a very good point. So
Mr. Chair?
yung intended beneficiaries natin who are the farmers who deposit their produce in the warehouses must be consulted, because for them to tell us if they appreciate the effort or not. Kasi this is for them. Actually, this is for them. They will have, di ba? All of a sudden, the trust in the negotiable instrument is there. They can now access financial markets or credit, di ba? So this is really for them. So good point. So
Mr. Chair, if I may
yes.
add just a small point.
Yes.
I'm specifically referring to the sugar planters. They should. I'm requesting the committee to consult them, considering that I have received numerous inquiries regarding this bill. They may have misconceptions that the bill is singularly focused on the KEDAN. So I'm asking that they may likewise be consulted, Mr. Chair. Thank you.
Okay. Yes, but can we hear from yung on the point of that this is singularly directed at the KEDAN? Can we have Secretary Teves to enlighten or to answer that point? I'm sure it is not, pero can we address that concern, Secretary Teves?
Yes, just to add to the discussion, with my little exposure on the sugar industry, I agree with the observations of the executive director. In fact, in our updated Q&A, Mr. Chair, we said that in answer to the question, are all warehouses covered by the proposed bill? Is accreditation mandatory, or will existing warehouses need to go through accreditation again? Our suggested response, subject to the observation of the technical working group, is that no, the bill only covers warehouses that are engaged or want to engage in the issuance of warehouse receipts in the prescribed form by the law or bill. Existing warehouses will only go through the accreditation process if they want to engage in the issuance of warehouse receipts. So in other words, the existing KEDAN system, efficiently working, should continue without having to go through the process that we're suggesting for the other sectors of the economy or agriculture or SMEs. That is our suggestion, Mr. Chair.
Thank you, sir. Mr. Barrera, KEDAN system is paper-based.
Correct, Mr. Chair. Yes.
For the record, sir, paper-based.
Yes, sir. It's paper-based.
You want to remain paper-based.
Yes, sir. If you will consult the planters, they would prefer that because hawak nila, sir, eh. And they live in rural areas. Kung mahirapan yung mga estudyante natin access the internet for online education, the planters would be concerned if they do not see their kids. They prefer it paper-based. But the committee is welcome to consult with them.
Yes, as I understand the bill, Attorney Abada, correct me if I'm wrong. There is paper and electronic, and in case of discrepancy, the electronic form prevails, di ba? Parang ganun yung ating bill.
That's correct, Mr. Chair.
Yeah, this bill is really about electronic warehouse receipts. So-
Electronic, but we don't issue. This bill will not ano tawag mo doon, accommodate the issuance of paper warehouse receipts in addition
Well, this-
to an electronic copy.
This law will not is not actually for paper-based warehouse receipts. But you know, the rules of negotiability, that's already in our legal system, for something like this. We can also review the repealing clause and amendatory provisions of the law, and reconcile it with this system of the cadence, the sugar industry.
Yes, Commissioner Francisco.
Yes, Mr. Chair. I believe that there's a provision in the proposed bills that the electronic with a paper receipt, the paper warehouse receipt can still be issued, but in case of in case there's a discrepancy between what is on paper and what is on the electronic receipt can prevail, Mr. Chair. And just to comment on the sugar industry concerns, Mr. Chair. I believe that I think it's open. It's an open secret that the cadence system is really a working system. I mean, so I don't think if it's not busted, then we should not tinker with it anymore. But in fact, I think the concept here is really to build on that system. In fact, when we were talking about it with our consultants, we really wanted to reach out and consult with the sugar industry because it's their system that's working. The other industries may not be as successful in the warehouse receipts process, Mr. Chair. So we want to build on that. We want to learn from them so that maybe, in fact, just the top of my head, maybe if it's there may be certain parameters or certain information that we can feed the system from the sugar millers and the sugar industry, just so that we have sort of, because right now there's no central authority that collates all this information on warehousing, Mr. Chair. So maybe I think in that sense, if we're able to collect data from all warehouses that want to issue or will intend to issue warehouse receipts, then I think the government itself even will have a better picture of commodities and food requirement, food stocks, etc., all over the country for all industries, Mr. Chair.
Mr. Chair.
Secretary Teves?
Can I read the two short questions and suggested answer in relation to the discussion?
Go ahead, sir. Go ahead.
Can warehouse receipts be issued or transferred electronically? Yes, the bill provides a general framework for issuing, transferring, and recording warehouse receipt transactions within an electronic platform registry linked to registered and accredited warehouses. The electronic platform will provide for a cheaper, speedier, and more secure method of transferring warehouse receipts, increasing liquidity in the marketplace. The next question is, can paper receipts still be issued? Yes, paper receipts may still be issued, but only as a certified true copies of electronic receipts. In case of a discrepancy, an electronic receipt prevails over a paper receipt. Now, going back to the issue of the sugar industry, if they have their own system and it's working well, and they don't want to register under the present law, they can continue with their paper system. But for those who will register under the law, this is the suggestion, Mr. Chair, for your consideration and the technical working group. No?
Yes, sir. Yes, sir. It's more or less a voluntary system naman.
Yes.
Yes,
That's
yes.
right.
Okay. So it's a voluntary system. Good. Okay, so ganito na lang, we will hear from SRA, Attorney Tihida here, and then NFA since they are present. Pero COMSEC, before I forget this, COMSEC, are you here? Are you online? Mamaya na lang. I think we lost. COMSEC, siguro ganito, to shorten the process, let us just reach out to all of the farmers co-ops, farmers associations, no longer invite them to a hearing, but reach out to them and then request them to submit the position papers on the said bills on the warehouse receipts law. Ganun na lang. So we will save time. But we reach out to them immediately. Okay, by snail mail, by call, and by email, by electronic process. Let's exhaust all possible means, and then list down all possible farmers associations that we will write to. Okay, Attorney Kerubin and Miss Jingle. Okay, please. Okay, so Attorney Tejida of SRA, para let us listen to the SRA.
Yes, Mr. Chair, no? Magandang hapon po at sa lahat, Your Honors. We cannot but absolutely and completely agree po sa PSMA on their stand on this issue. But at least pasalamat po kami na medyo na-clarified na this would be at least a voluntary system and we will no longer destroy a very, very much working system under sa SRA po. No? As deputy po ng regulation, tamang-tama po si Attorney Kokoy, our former board of director po sa SRA, na mahihirapan po kami sa SRA. No? We cannot think of a system na kung hindi po kami papayagang mag-work on our working system, medyo mahihirapan po kami to at least comply with our mandate, and that is to regulate nga po yung sugar supply based on the kidans and the production of farmers. So yun po. So as part of SRA on behalf of Administrator Serafica, yung sanctity naman po ng kedans, tama po, at least we're clarified now that we can still continue. We will no longer create confusion among our stakeholders, especially po mga small planters at mga planters din na malalaki. Sanctity po ng kidans sa aming present system, nandyan po kami sa SRA to really work on safety nets, hindi lang po safety nets, but we have various regulations, we have various rules and regulations through our sugar orders to prevent po itong fraud ng pamimeke ng mga kidans. Then we also have existing our book of penalties na marami na rin pong kahit pa paano po ay nape-penalize, at least they were warned of severe penalties if they violate the sanctity of the kidans. So yun po, we are thankful to have been invited to this hearing. Then reiterate ko lang po yung stand namin sa SRA as is we agree with the PSMA stand, and we hope to clarify this matter, and we also thank our resource speakers and yung clarification po na we can continue with our working system. Thank you very much po. Magandang hapon.
Before the NFA, no? NFA, standby muna. I'll get your position. Attorney Abad, I have a question. Senate Bill 632, Section 17. Ito po ang nakasulat dito. Registration of warehouse operators. All warehouse operators using warehouse receipts are required. A word is required to register and obtain accreditation with the council. All warehouse operators who are not registered and accredited with the council are prohibited from issuing warehouse receipts. So ayusin natin yun, because if a kidan is a warehouse receipt, from the as written, we would the opinion, my impression is that covered si di ba? Covered si sugar warehouses. So, and since this is voluntary, do you confirm that, Attorney Abad? This is a voluntary system. So, parang as an industry, pwedeng opt out si sugar industry from the voluntary system because they will still continue to be issuing warehouse receipts.
Oh, it's yung what we're talking about voluntariness is if you want to be participant in an electronic warehouse system, then you have to comply with this law. So there's an obligatory part if you want to be part of it. But if you have your own system, like conceivably, if there were some place like some town that was issuing some form of paper, negotiable paper receipts, no, to each other, that would be outside, no, the coverage of the law. But of course, they will have their own legal. If they have problems about negotiability, then negotiable instruments principles will apply already. But in terms of regulation, if you want to be part of a system of securities that you're moving warehouse receipts electronically from one place to another, and maybe even developing a futures market, then you have to be part of the system. But if the sugar industry has its own system, it is a closed system for them to, I guess, to transact with each other, then that can stand also by itself.
Okay, so klaro naman tayo doon. It's if you want to benefit from this new system that the law will authorize to be implemented, then you join and comply. But if you don't want to benefit from this new system because you have a working system, not electronic, then you are not violating the law if you do not join the system. So I think tama ba yan, Attorney Abad? I think that's clear.
I wanted to add something also, Mr. Chairman.
Go ahead.
But I hope I'm not getting ahead of the committee on the work on reconciling the bills. But at the House level, we had decided to revise that initial thinking about having a council, no? Because ultimately it would go to the SEC for regulatory purposes. But the council concept might have created. We thought, no, that the council concept might create a new bureaucracy. In any case, the SEC will be calling all these other agencies as to the veracity and reliability of the warehouses. That's the reason why we shifted it back to the SEC from the council.
Yeah. Since we're using technology naman to guard against fraud and to ensure genuineness and authenticity, pwede na siguro kaya na ng SEC yan. Tama ba, Commissioner Francisco? We will use technology to maintain the integrity of the system. Kaya na ng SEC yan.
Well, Mr. Chair, actually, we do have experience in electronic registry. So we learned the hard way, but we have improved our registration system, for example, for corporations tremendously. And recently we were launching another online submission tool system. In that sense, yes, we have experience. Pero in terms of warehousing, warehouse accreditation of warehousemen, we don't have experience in that, and that's why we will need the support of the industries, working industries, so like the sugar industry, for example, for some ideas on how to set the system up and what types of experts we will need, as well as the system, the information that we will need to put into this system. And if I may add now, before I forget, Mr. Chair, there is also a provision, some conflicting provisions regarding appropriations for this new system, because under the Senate Bill 632 and Senate Bill 2049, there is still mention of sourcing funds from the General Appropriations Act. But in 2019, Mr. Chair, the SEC was granted, through the revised corporation code, granted the relative fiscal autonomy. So we are no longer part of the GAA, Mr. Chair. So I believe we will have, fortunately, unfortunately, we will be sourcing the funds from internal sources. SEC sources, Mr. Chair.
Thank you for pointing that out. Medyo, if we would not have been aware if you had not pointed that out. So we will take a look into that, sir, Commissioner. We'll take a look into the possible conflict of the concepts of the new concept. Okay, so can we listen now to NFA? Si, Attorney Villaferte? Attorney Villaferte?
Yes, good afternoon. Sir, good afternoon, Honorable Chairperson, Senator Coco Pimentel. We also would like to greet our former NFA Administrator, beloved NFA Administrator, Attorney Anthony Abad. Good afternoon, sir. Sir Chair, the NFA Administrator, Attorney Judy Carol Donsal, is sending her apology for not making it today. But she said that we are supporting this new bill, modernizing and strengthening the century-old Warehouse Receipts Act, Your Honor. So we will submit our official position paper soon, sir.
Thank you, ma'am. I think someone from the DA logged on. Sino yun? Comsec, maybe the DA wants to say something. Department of Agriculture.
Yes, good afternoon, Mr. Chair.
Please identify yourself, sir.
My name is Kennedy Garabiag from DA Agricultural Credit Policy Council. May I read our position paper, Mr. Chair?
Sir, go ahead.
First of all, we would like to thank the committee for inviting to this hearing on proposed Warehouse Receipts Act. And on behalf of our Executive Director, we welcome and support the proposed legislation to modernize the warehouse receipt system. We agree that establishing an electronic warehouse receipts registry, which the bill aims for, could promote the reliability and therefore enhance confidence over the integrity of their warehouse receipts as proof of ownership of stored goods. And this could encourage the use and acceptance of warehouse receipts as security or collateral for loans. And of course, benefit the agricultural sector in terms of increased access to credit, particularly from the banking institutions. And we would like to also recommend for the consideration of the committee, Mr. Chair, Your Honors, that since the proposal is highly technical and legal in nature, it must ensure that capacity building would be in place for the stakeholders, the farmers, the warehouse operators, the oversight agency, the financing institutions, among others, to provide them sufficient knowledge of how the warehouse receipt system works and how to benefit from it. We have actually submitted our official position paper, Mr. Chair, to our DADLLO. And I think they're preparing a unified position on this bill.
Thank you.
That's all,
Thank
Mr.
you.
Chair.
Thank you, sir. The committee awaits the submission of your position paper. Okay, any other comments? Kung wala na po, maybe it's time to take our lunch. Parang na tayong Spanish lunchtime. At Mr. Barrera, kanina pa tayo. Okay, this is what we will do. I will now call for a technical working group to harmonize and finalize the versions. No, that we have at least 3. No, Attorney Kerubin, we have 3. We have 2 Senate bills and 1 House bill. But we will delay it for a bit. No, we will delay the actual convening of the technical working group to give time to the farmers associations to submit, to be consulted, and submit their position papers, and all of the other interested agencies, the NFA, Agri, and other government agencies to submit your position papers. Okay, so maybe in 2 weeks' time, kaya na ba at Attorney Kerubin? Can we call now the technical working group, the convening of the technical working group after 2 weeks?
Yes, sir. Sige.
2 weeks from now, 2 to 3 weeks from now, but immediately contact the other farmers groups if you want to consult with. Okay? So is there any objection to this approach, Attorney Abad, that Secretary Teves, gano'n na lang, will give us 2 to 3 weeks to...
Yeah, sure, Mr. Chairman. Thank you very much.
In the meantime, we will be studying the 3 versions anyway. So this is not, we are not losing time. DOF, no, Ma'am Santa Ines, we will await your position paper also. DOF, okay. Okay, so at least we have found the solution for us to be able to take our lunch. Okay na sir, wala nang ano. No. Okay, so I think we have disposed of all the items in our agenda except one about the contractor license bill, especially the reciprocity angle. So because of that unfinished business, I think I will just have to suspend this hearing. Comsec, ganun ba? Can I just suspend this hearing because of that unfinished business? So, okay, so in the meantime, let me take this opportunity to thank all of you, all the government agencies, Commissioner, SEC Commissioner, SRA, DFA, NFA, our Secretary Teves, Attorney Abad, and of course, kung saan tayo marami tayong natutunan from the sugar miller. Sana nawala na si Mr. Barrera. This land. Okay na. So I think we can now safely suspend our session. So thank you to all of you.
Thank you.
Thank you very much.
Thank you, Mr. Chair.
So our hearing is hereby suspended. Thank you very much.
Thank you, Sir Gary. Thank you, Sir
Thank you. Thank you.